Anything before we get started?
No, the only, we are going to be showing Dr. Reutemann, we spoke about it before, these records so that he can say that he looked at it, but we're not going to put them into evidence.
Correct, because there's 1,000 references to the prior sentence in them, and so they're too hard to redact. The ones that I want to use in cross, I pulled out. I don't think they're going to use any specific ones, so we're good.
I just wanted to know that's what we would.
I'm not going to be traumatized when I see a giant stack of records that we're going to be going through each page of those.
No, you will not be.
If you want to, I did it because of your sensibilities, yes.
So I can't tell you how much I appreciate
What?
that.
Is that on the record?
Your Honor, can you read the, what we crafted yesterday before the arrest today, as far as the prior
Judicial notice. Well, I'm going to use it in the process.
Judicial notice,
Dr. Reutemann.
let's see, I've got it on my desk.
I'm trying to put these back
Uh-oh.
as you had them, but
Let's see.
most of, yeah.
It was all the way down.
Oh, I've got it. So the court takes judicial notice that in 2002, a court issued an order resulting in this penalty hearing being conducted.
Correct.
All right, I'll do that. You're going to use that in,
Dr. Reutemann's cross, I anticipate it'll come up.
all right, do you want me to, I can do it as when we first get in today, or I can do it right before your cross-examination?
I prefer to start with it.
Okay. All right.
I have a copy of 2 special verdict forms that I've given copies to the prosecutor. The longer one has proposed changes in red to the form that the prosecutors had submitted, and then the shorter one is one that we've come up with as well. But I didn't know if you want those.
Go ahead and give it to me now, and we'll talk. We'll talk about it after we get done with everything today. I want state also sent me its thoughts on depravity of mind. I didn't look. I assume you copied. That's
We did.
counsel.
Yes, we have copies of that.
All right. Okay.
We have one photograph we've shown to this state. I don't believe they're objecting to it being added as an exhibit.
All right. When the jury gets in here, you can ask for it to be admitted, and I'll put on the record that the state has no objection, and we'll admit that.
We're going to use that one, John.
That's,
Use that one, John. Did you want to use that with Reutemann? What did you say? No, I'm
All right. Anything else?
No.
no, you're
Okay. And Mr. Oh, I did have one thing I needed to raise. Juror number 2. She indicated she came up to the marshal. She indicated that last night she went home and was checking her Instagram account. Noticed that she had a new follower on her Instagram account, and looked at it, and the new follower's name was Valero. She blocked it at that point in time, but in view of the fact that I've said over and over, if someone should try to contact you, to contact the marshal and let know. She said there was nothing other than she had a new follower whose last name happened to be the defendant, which she thought was just sort of odd. There was nothing like any messages or anything inappropriate or anything like that that was conveyed, and she just went ahead and blocked it in view of the fact that she's a juror in this trial. So let me just ask, I mean, is there any Valero that's a relative of the family?
Not that I'm aware of it. Unfortunately, I don't know what Instagram is.
From what
Social media account.
it's a social media account. Essentially, people share pictures primarily on it. You post pictures of yourself or your friends. If you have a business, you post pictures from your business. Whereas Facebook is more newsy, Instagram is more picture-y. I mean, so anyway, she reported that. Does anybody want me to do anything in that regard?
Not from the state, the defense wants her canvassed anyway, but I don't.
Your Honor, we would request that she be advised, independent of the other jurors, that there's no one from Mr. Valerio's family by that name that it, you know, we
I don't have a problem doing that.
someone from the family is trying to contact her.
Why don't you have Ms. come in now, and I'll go ahead and advise her of that. How are you today?
Good, how are you?
Good. Actually, why don't you just stay standing? I mean, if you want to sit down, go ahead. This will be quick, and I'm going to send you out to meet with your. You indicated to the marshal that you yesterday were checking your Instagram account and found you had a new follower whose name happened to be Esteban Valero. I just wanted to let you know I've talked with counsel, and there's no family member of the defendants in this case whose name is Esteban Valerio. So you have just somebody out there who apparently wants to follow you. I would go ahead and keep him blocked. You indicated to the marshal that you kept him blocked, or you blocked him. I'd go ahead and keep him blocked until after this trial, but don't think anything about that in any way.
Okay.
All right, thank you very much. If you go on out, we're going to be bringing you all in a couple minutes. All right, actually less than that. We'll be bringing you in 30 seconds. I need to go. My kids set up an Instagram account for me, and I guess I need to go on it and see what it is, because I have no idea. I'm not even sure I can get on it, because I don't know what my username or password is now. Okay. Let me formally call, well, I'll have a call the case, and you'll come in, you'll introduce yourself once. All right, let's bring him in and get going. All right, let the record reflect the presence of the attorneys for both sides, the presence of the defendant, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Okay, let's call State of Nevada versus John Valero, case number C077268. Counsel, go ahead and make your formal appearances for the record.
Mark DiGiacomo and Giancarlo Pesci for the state.
Tom Arrington and Tom Pitaro for John Valerio.
Oh, yes, the interpreter. Let me have your name again.
Mildred Alfuero.
All right.
R-Q-E-R-O.
And you understand you're still under oath from the other day?
Yes, Your Honor.
All right, thank you very much. Ladies and gentlemen, I apologize for getting started a little bit late today. My morning criminal calendar ran until 1:05 this morning. And so my staff did a quick bite to eat and get it started. But I appreciate your patience. I'm sure everybody here will tell you that we spend too much time on the criminal calendar with the sentencing and probation revocations. For whatever reason, I feel we need to take time sometimes with those. So I appreciate your patience with me on that. It's all my fault, nobody else's. We'll get started then with the next evidence that the defense wishes to present.
Thank you, Your Honor. Call Dr. Norton Reitman,
Okay.
and he's outside. I'll grab him. I can grab him.
Actually, hold on just one second. I remember I was going to do something before we got started. Ladies and gentlemen, if you remember yesterday, Mr. DiGiacomo at one point asked me to take judicial notice of a court order, and I said I would continue that. By judicial notice, the law allows me in very limited circumstances, because for the most part, you are the ones who determine the facts of the case, but the law allows me in certain circumstances to take judicial notice, or in other words, instruct you that you may consider as a fact to the degree you feel it has any weight or substance or value in your deliberations, certain information. And one of the things that I can take judicial notice on is prior orders that are in this case. And so I do want to inform you, to the extent that you feel it has any weight or significance in that in your deliberations, that in 2002, a court issued an order resulting in this penalty hearing being conducted. All right, with that, go ahead and bring in Dr. Whitman. Doctor, if you come on up to the witness stand. There's a couple of steps there. You get to the top, stay standing, and my clerk will swear you.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I swear.
Please be seated. Please state your name and spell your first and last name for the record.
Morton A. Roitman, M.D., N-O-R-T-Y, R-O-I-T-M-A-N. And if I could have a glass for water.
There's no, this is not a glass, or is there? Oh, they're okay.
It's just hiding from my.
All right. There's also some Kleenexes hiding there behind you, but you didn't need those.
Hold on.
Huh? I was thinking more in terms of a cold.
Oh, okay.
We'll see after you're done with your examination. Yes, so.
Good afternoon, Dr. Reitman. Hello. If you could tell the jury, if you would, what your background is, your educational background.
I went to the University of Wisconsin and got a Bachelor's of Science in Psychology, then medical school at the University of Illinois. Then I went to school at the University of California in San Diego for residency training, specialized training in psychopharmacology, and then up to Los Angeles, and I got a fellowship in child and adolescent psychiatry and some administrative training. That was around 1985, and since then, every 2 years I take 30 to 60 credits in continuing education, and I've been in Nevada since 1985.
Since you've been in Nevada since 1985, can you tell us the nature of your practice and affiliations that you have?
At first I ran the state hospital up in Sparks, Nevada for 3 years. And then I came down here, started a private practice and worked at one of the private psychiatric hospitals and started a clinic, Harmony Counseling. In 1995 I sold that. I've been in just private practice, seeing one patient at a time. We're doing work like this, testifying since then. Lately I've been doing more forensic work or report writing. Insurance companies might ask my opinion about a case. Juvenile justice sends me cases when they want. They need to know, should the youth be placed for treatment, or is it not a treatment problem? Is it just criminal activity? And I go up to Caliente Youth Center once a month and I see the juveniles up there in detention. I have a few contracts as well with the school district, second opinion clinic, like that. Mostly at this stage, I do teaching, I do consultations, less and less direct patient care.
And where do you teach?
At all three medical schools. Roseman, I'm the clinical faculty there, and UNLV, the new medical school, and the one up in Reno, I'm still on faculty there.
Dr. Raymond, you were asked to evaluate Johnny Valerio.
Yes.
All right. And just to freeze, did you bring your report with you?
I have it on my computer.
Okay. If while we go through this, would it be easier for you to be referencing your report?
Yes.
Okay. Tell me when you're ready.
Assume the state doesn't have any problem with the doctor
No,
referencing his report during his testimony.
I don't, and we have a copy of the report.
All right.
And I discussed that before we got here.
Okay, good.
Okay.
All right. At the time that you were asked to interview or evaluate Johnny Valerio, you were aware that he had been convicted of first-degree murder,
Yes.
and part of your instruction was that we cannot relitigate the murder.
That's correct.
So that conviction stands, and you understood that when you started your process of evaluation.
Yes.
Okay. And so what I want to do is then direct you to the evaluations, but first, could you tell the jury what sort of documents and items that you reviewed to aid you in talking to the jury about what your findings are?
Mr. Valerio filled out a questionnaire like doctors almost always give patients, listing aspects of his history, medication, treatment, psychiatry, and medical, as well as a symptom checklist. I received some material that was already worked up, a chart of his family, and then I spoke with his mom and his stepmother, his dad and his stepmother by phone. There were lots of medical records and records from the Department of Corrections about any problems that he had and his conduct while he was detained. And I reviewed certain materials. I did some research on brain development and pulled up some articles that I thought were relevant to his case. There's the diagnostic manual, which is like the constitution of psychiatry. Everything that I say should be based on the book. Way back, it used to be psychiatrists would just say, because I know this, I have all this experience, this is what I think. But we've had to standardize the profession, and that's the Diagnostic Statistical Manual, the DSM-5, and every once in a while it's updated. So that's really the foundation for all professional opinions. There was a amicus curiae brief that was submitted by the American Psychological Association to the Supreme Court. It was filled with information about sentencing, basically for younger people, and aspects about brain developments, character development, and things like that that I thought was relevant to the case.
May I approach, Your Honor?
Go ahead.
I am showing you, if you could just look through these and just to identify them as being the prison records and as they pertain to Johnny Valerio.
Well, the first book is labeled Trial Transcripts. I don't believe
Too many binders. These are these are heavier. Wrong one. Same white binders. Take a look at them if you would. We are not going to introduce them, so no one has to sit and read them all, but we just want to get the jail records that you're going to be talking about, that these are in fact the records that you reviewed and were provided to you from the Nevada Bureau of Prisons.
I'm just doing a sampling here. They look like the records that I reviewed.
What are the other volume too? So it's not very anymore.
Yeah, these are the types of records that I reviewed. Medication orders, physical complaints, and problems with conduct, incident reports, things like that.
And the items that were in the binders, that made up a part of what you would determine John Valerio's life, if you will, has been like in the past decades.
Yes.
And you were aware when you looked at them that they were in fact his prison records?
Yes.
And that the prison records have the good and the bad, whatever it is, that there's a record of it was in those binders.
I've done many cases, and that's usually the case. I can't say whether something happened and it wasn't reported, but it's a record of the people who were overseeing him and responsible for his care and conduct.
Now, you were asked to do an evaluation by me and Mr. Erickson.
Yes.
And when approximately did you do that?
The first examination was June 23rd, 2014. We had discussed his case before then, so I knew what my assignment was.
Did you, on the evaluation of Johnny Valerio, did you have the opportunity, in addition to, as you said, looking at prison records, speaking to his family and those type of records, did you actually interview him?
Yes.
And is that something that you would do as a licensed psychiatrist rendering an evaluation or opinion?
Yes.
And you in fact did that?
Yes, I did.
Can you tell us when you did that? Do you have that there?
There were 3 occasions that I saw him face to face. There was June 23rd, 2014, and then the September that same year, on September 14th, and then this year, June 20th, 2017.
And did you feel those were sufficient to aid you in rendering an opinion for the jury?
Yes.
And did you explain to Mr. Valerio the limitations of what it is that you were doing, that you were not there as a personal psychiatrist or to deal with the issues of guilt or innocence?
That's right. This role is different. His doctor would not be cross-examined, held accountable for opinions. I was minded that I, in my view, assisting the court in making a decision, being somewhat of an educator, and subject to cross-examination as a test of my reliability.
Now, we had what is referenced, or what we call a psychiatric symptom inventory.
Yes.
Okay, and maybe if you want to go to page 5 of your report, if that will help you. Could you just tell the jury basically what that entails?
I'm a medical doctor, and I do what all medical doctors do. It's just the content. I'm not a bad doctor. I examine the mind and the brain. And so just like my doctor would say, do you have any pains in your knee? Are you having any trouble breathing? Psychiatry is a similar checklist. And I don't ask about the knee so much as I ask about depression and anxiety, obsessive compulsive symptoms of psychosis, all the characteristics that are listed in that diagnostic manual. I have to review it because sometimes somebody will come to see me and they say, I'm nervous, and then you find out that they got another problem that they didn't identify. And the nervousness is caused by the thyroid or by some other psychiatric condition. So this is called a review of systems. Okay.
Can you give the jury, tell them, Dr. Reitman, basically, in a general view, what your findings were after the psychiatric symptom inventory?
Reviewing for mania, psychosis, obsessive compulsive disease, post-traumatic stress disorder, things like intellectual problems or neurodevelopmental, ADHD, depression and anxiety. He didn't report any symptoms. And the medical records did not show any psychiatric symptoms either. Exam after exam, he was evaluated as no psychiatric problems.
And that what you were evaluating was over since the conviction and since he's been in prison.
That's right. On 3 occasions, I couldn't find symptoms of the psychiatric disorder.
And would you expect to find them if they existed?
Yes.
In addition to that, what sort of history would you look at in a family history?
A family history gives you a clue that there might be a tendency in the family for depression, anxiety, psychosis, or mania. Some of these things seem to be at least familial, if not genetic. And so if there's a strong family history of one disorder or another, it would make sense if the subject of the examination had those symptoms too. But it's not like absolute, because, for instance, even schizophrenia and identical twins, only one out of 50% of the time, one twin can have schizophrenia and not the other. So it's not like brown eyes. It's not that strong of a correlation, just an indication.
And did you want to go into what his background was, not in terms of the conviction, but leading up to that period of time?
Yes, psychiatry benefits from not just looking at the snapshot of how somebody is right now today, but trying to reconstruct the videotape of how they've been, how they got to where they are now, taking into account certain developmental stages, things that you would expect like puberty, changes that occur, emotional problems that people have at certain stages of life events that cause reactions. Sometimes they're just life itself, feelings that come with day-to-day experiences or tragedies or trauma. And so the placing the person within the context of their history is one of the critical competencies of a psychiatrist.
And did you do it in this case?
Yes.
You can just give us a quick overview to the jury of if it wasn't a general meeting.
Yeah, there were some problems that came up. There was disruption between his parents. The family broke apart. John felt that his mom was the cause of it for various reasons, but she had been his primary caregiver. When the judge gave him the choice of parents, he chose his father because he thought that was the right thing to do. The father was not responsible for the breakup, the mother was. But it had been that his mother was there, always, taking care of him, the primary parent. And so from age 9 on, he was under-supervised, felt abandoned, even though he was the one that made the decision. Told me he wished, looking back, that the judge never gave him that option. He was too young to make it. And starting at age 13, he started to get in trouble. He was under-supervised, ran wild in the community, got into trouble, started smoking a lot of marijuana, which in his case, I think it really was self-medication, because he was anxious, awkward, found himself in situations where he didn't have the skills to handle, and so his use of marijuana became pretty exceptional up until his last incarceration.
Now, what I want you, if you would, I mean, that was the history. And, where's that picture?
What did we show?
This one's 56. We are 56?
State 56.
Right, state 56.
Right. All right, good.
That was in this case, not.
Okay. Ours is, all right, I understand.
Okay. And I want you to take a look at that. And I want to identify that as a picture of John Valerio at age 21 at the time of the crime that was in here. Okay?
Yes.
Now that person is not the person that you evaluated.
In many ways, no.
And if you'd stand up, John. Is this the John Valerio that you evaluated?
Yes.
And what I'd like you to do, if you could help us on this, explain how we went from the 21-year-old to the 52-year-old person. That is, from your evaluations of him.
Well, he described to me almost like he woke up when he was detained for this charge. That he took stock like a person with alcoholism, finally gets it that they're an alcoholic, that he saw himself as a drug addict, irresponsible, cruel to his family, not taking responsibility for his life. And instead of doubling down and getting worse and worse, he took a personal inventory and got better. He valued the relationships that he had. He corrected his behavior. He developed more ability to control his impulses and his anger. And he valued the idea of becoming a better person.
Let me ask you this. I mean, this was this a gradual process of growth?
Yes. I mean, just taking an inventory is not the same thing as making the change. I see a lot of adolescents who committed crimes, and some, they're just armored. They don't care. They don't buy in. They have their needs, their wants, their desires, and they just keep going with that. And others, they look back, they think that they were stupid. I ask them routinely, if you could go back in time and talk to yourself, could you talk yourself out of what you were doing? And most of the time they say, no, I was just not listening. I wouldn't listen to anybody. I wouldn't even listen to myself. They're driven by other spirits. Something else is driving an adolescent that doesn't happen so much in young adulthood and thereafter.
But if I may, now John was 21.
Yes.
When this happened.
Yes.
Now how does him being a 21-year-old fit within what your evidence?
Some young people develop insight early, some later, some not at all. Some develop motivation to change, some don't. So there is a range of time periods under which young adults, teenagers and young adults can undergo their transformation. Some people put it way off, and some people never do it at all. But the science of this shows that between the ages of around 16 and 24 is when the hormones stop controlling the person so much, the brain develops more balance, and the person's moral structure firms up. In fact, the majority of criminal teenagers do not turn out to be criminals in the long run.
When you were dealing with John specifically, were you reviewing his record, i.e. those two volume binders I gave you? This is where you got this information?
Yes.
Well, this is what you used?
Well, a lot of psychiatry does depend on the person that's being examined, the question and answer. A little bit like this. I'll be answering questions here, and I would talk to anybody who's being examined about different aspects of their life and do it over time, look for the consistency of the history of everything that's together. There are certain tells when people are not telling the truth, or sometimes people, in different cases, they cling to their illnesses and using their psychiatric condition sort of as an excuse for their behavior. So there are different factors. One is the records themselves. You'd like to see them consistent with what the person has said and what is told by their family members and other sources of information.
Now, for example, you had basically a 30-year history.
Yes.
And when the person goes through the process that you're describing, John has gone through to lead him here today to the person he is today. Are there bumps along the road?
There can be, yes.
And we saw already before you got here that 15, 17 years ago there was an incident. 20-odd years ago there was an incident.
Yes.
Does that defeat, if you will, your analysis of how John is today?
No. And the diagnostic manual gives us some guidance on this. So again, we can't just all say, I think this is true, so it must be true. The manual says that a person's character, you analyze the character to look at patterns that are persistent and consistent. You know, anybody can make a mistake or do something illegal or be violent a few times in their lives. That's not the same thing as a persistent pattern that the diagnostic manual requires. So there were incidents, but I didn't see that persistent pattern of low morality, violence, or meanness in spirit.
And that was during the periods that he's been incarcerated.
That's right. That's right.
Last 30-odd years.
The impression I got from him and his parents, and the fact that he had a record before, is he was at risk of developing that pattern, that persistent pattern. And I've read records of inmates who have turned out bad, for lack of a better term. The reading of his record and the examination and what his parents told me were not like that.
And when you say that you've seen people that over periods of time, even with incarceration, don't change.
Yes, that's right.
So that's not it's not unusual to find people in an incarcerated, restricted area who don't change.
That's right.
But here's what you've seen is someone who over the period of time has changed.
That's right.
Can you give us some of the areas that you think would be important for the jury to know of how this change proceeds and where we are today?
Do you mean what I read in the records?
Yes,
Show his change?
based on what you read in the record, talk to his folks and him.
Yes.
Over the period of time that leads us here to your testimony today.
One of the major things is that he gave up smoking marijuana, and he never wanted to return to doing that again. He had been detained previously and just resumed his lifestyle right back to where he was before. This time, he figured that it was part of his failure, chronic failure,
No.
and he wanted to get rid of it.
Okay. Now, there was an incident, we heard about 17 years ago,
Yes,
that there was some marijuana
right. Well,
in the jail.
there is access, inmates have access to substances. Years went by with no relapse. He had a relapse, and after that, he thought he could handle it. I talked to him, like many people with addictions, they think they can handle it, and they have to test it out. He tested it out, he couldn't handle it, and so since that point, there have been no positive urines, which is actually different than many people in recovery. Many people in recovery have multiple relapses before they finally get it, if ever. So there was one incidence of drug use.
Okay. Now, how long ago was that?
I think 2000, year 2000?
2000?
Yeah,
So 17 years ago?
yes. Yes,
But in 2000, Bill Clinton was still president,
yes,
right?
yes,
I mean, it was a long time ago.
yes.
And since then, there has been no problems with John since 2000.
No evidence in the record and no evidence in self-report. If he was clean and sober since then, this is what the record would look like. No further incidents.
Now, that had to do with that one marijuana, but any other instances since 2000?
He had contraband, razor blades taped together, a TV antenna, I think a couple nail clippers, Elmer's glue, a button, things like that. He maintained that majority of this was for arts and crafts. I think that was written in the record, that's what he saw it as. Some of the charges were dismissed and some of them he received penalties for.
But those went back even further than the 15, 17 years. That went back into the 1990s.
Yes, I think 1993, 1998. Occasionally, there were these violations of the rules to some degree. There was some altercation, physical altercation. I think it was judged not to be the perpetrator in that regard, but that he was defensive. A scratch across his cheek at one point. Again, I mean, I evaluated this distinctly different than some of the records that I reviewed, where somebody's brawling all the time, always alpha male, trying to, get into it, establishing a dominance relationship with others. A totally different record. He had a totally different record than that.
But you were aware of these things and you knew how far back they went.
Yes,
And knew that starting with the last incident, it all appears to be 17 years ago.
yes.
And what does that tell you, that there's been no instances in 17 years from 2000?
Well, it tells me that he has the ability to self-regulate. That regardless of how he felt, what he wanted to do, what he feared, what the prison environment was like for him, he was able to maintain a course and stick to his decisions to be the person that he wanted to be. That is a capacity in neuroscience called executive function or frontal lobe function. That's something that we treasure. When our teenagers say, thank you, Dad. I know it was rough, but I'm really sorry. Like my boys have done, they've developed an executive function, the ability to reflect and to make decisions and to push down the impulsivity that they had before. Teenagers, not 100%, but many don't have that capacity. John developed it, otherwise the record would have read differently.
And that's what I wanted to get into, that he developed it.
Yes.
This is not to say that he had it at the time of this incident, but as the evaluation process, he has it.
Yes, I think actually the marijuana was part of his executive function. Aggravation, anger, bad feelings. His solution was not to think it through and get to a better place. His solution was to light up and change his feelings using a substance. I think it was behind, actually, because he was so reliant on that drug for so long. He he was immature in his ability to use his own mind to function better.
Which, as we know, 31 years ago manifested itself in a very bad, terrible situation.
Yes.
The thing is that what I want you to, is this growth, this maturation, is this something that is possible?
Yes.
And so a person who has done terrible things years before can in fact change.
Yes. Providing that they have the character to do it. I mean, there's a certain number of people out of every 100, a certain small number don't develop the strong character or moral development that they need to do the right thing.
And they have to want it with them.
They have to want it, yeah.
And if they don't want it, then it doesn't really matter.
Some people want to be resentful, they want to be the victim, they want to be angry, they want to show that they're strong, they want to feed their own ego. That's not what he wanted to be better.
And how would you describe John now?
He's a peaceful helper. When he gets a chance to interact with others, they ask him, some of his peers say, how do you do it? And he says, you know, I just take a deep breath, I think forward thinking, I choose to be the type of person that I want to be, and then he enacts it. I think one of his peers said, man, you should write a book, because he, when given the opportunity, if somebody's agitated or angry, upset, he has the natural ability to be there with them and then help them see it through. So he's like a natural peer counselor in the times that he's able to interact with his peers.
And that John Valerio could not have been 130 years ago.
No, that wasn't who he was back then.
But that's how you believe he is now.
Yes, after having interviewed him several times and look at the confluence, what he says, how he appears, what his parents say, and how the records read, it all makes sense to me.
And so I think what you're telling us is you don't just take one piece out here and say 20 years ago this happened and another piece over there. You have to look at the overall development over the last 30 years.
That's right. I think there are very few people, including myself, where I could say 100% of the time I made the right decision, that I made no mistakes, that I didn't screw up.
And if you could go to page 18 of your report, and could you tell the jury what your conclusion is as a doctor of psychiatric medicine in Nevada concerning John Valerio?
To a reasonable degree of medical certainty, that means that I've used the methods of my profession. Based on the examinations, interview, and research into the adolescent development of the brain, and review of the documents, I find John has redeeming attributes. He lacks characteristics of mental illness or psychopathic traits. He's developed into a pro-social individual who is not at risk to himself or others.
And that is your opinion.
That's my opinion.
Thank you, Doctor. No further questions.
All right, cross-examination.
Good afternoon, doctor. How are you?
Fine, how are you?
Good. You testified in capital penalty hearings 20, 30 times, somewhere in that range?
Closer to 10.
How about you evaluated 20 to 30 capital defendants?
Yes.
Is this the first time that you've evaluated a capital defendant 30 years after his crime?
No.
Have you reviewed defendants who have been housed like Mr. Valerio has been housed for the last 30 years?
Yes.
How many?
A couple.
Do you name any of them?
No. Names don't come to mind.
None of the names come to mind.
No.
When you were referencing all these defendants previously who had much more serious records than John Valerio, were you referencing the two that you can't remember now as you sit here? Did they have more serious records, or was their records consistent with the way that Mr. Valerio's records look?
Well, I was really referencing the hundreds of inmates that I've interviewed, not all of whom have committed capital crimes.
Okay, that's fair. you would agree with me that Mr. Valerio has been in a very particularized housing situation for the last 30 years.
Yes,
And you'd agree with me that the only real comparison you could do for that housing situation over the 30 years would be to other people that are similarly situated. Would you not agree with that?
I would agree with that.
And I'm asking you, since you said you one or two other people you've seen in a similar situation, how is it that Mr. Valerio's records match up? Are they consistent with it? Would you agree with that?
Could you ask me again?
Yes, for somebody who has been in his housing situation for the last 30 years, you'd agree with me that his records are fairly consistent with the other individuals that he was housed with,
Yes,
right?
yes,
You would expect to see that maybe there's some problems until they learn the rules, and then eventually by 35, 40 years of age, you stop seeing violations. You agree with me?
that happens a lot, yes.
And that's a fairly consistent pattern for people who've been housed for a very long time in a particular situation.
Yes.
So let me go back to, you said you've testified a lot of times. Let's talk about some of the things you've sort of explained as your role. Today you got up there and you explained that you're a psychiatrist, that means you're a medical doctor, right?
Right.
And there are times when patients come to you and you're treating them because they're seeking help from you.
That's right.
And then there are times when you're hired as what has been referred to as a mitigation expert, correct?
Yes.
And in this case, you are a mitigation expert.
Yes.
And your role, as you perceived it, as you've said in the past, would you agree with me, is to find something to help the jury decide to give a sentence less than death.
I don't see my assignment that way exactly.
How do you see your assignment, Doctor?
I see it's necessary to mine the records to look for facts that would support a conclusion, and that if it's not favorable to the defense can choose not to use me. So I don't have the intent to lighten up the sentence.
Do you perceive yourself as, well, let me ask this, do you perceive this proceeding as sort of a debate between two sides?
Yes,
Right, you said that before, right?
yes,
And you perceive that the one side will present evidence through you, and then we will test it through cross-examination.
yes.
Okay. Have you said in the past that, well, let me ask this. You've had a client before that you said was not motivated, correct?
I have had clients like that, yes,
And then specifically, so that we're all on the same page, Mr. Belcher.
yes,
When you use the term not motivated, meaning he wasn't willing to help you provide information that would provide mitigation to his jury.
he didn't have the intent to reduce his sentence. He wanted to maximize his sentence.
And so during the course of your interview with Mr. Belcher, he told you, my mother never abused me, correct?
Your Honor, I'm sure we can cross-examine it, going into particulars of another case.
I don't want to go too far.
I'm
I
not
want
going
to
too
have
far.
one more question here.
Yes,
And you had some information otherwise that suggested to you that he did, that he was abused by his mother.
I had somebody else's opinion.
And when you talked about he wasn't motivated, you were saying that's an example of it, that you chose to accept that his mother did abuse him as opposed to relying on his words.
No, I didn't reach a conclusion.
Did you provide that as an example as to why he wasn't motivated, that he told you his mother didn't abuse him?
He told me that he wanted to preserve his relationship with his mother, and he didn't want to use the court in any way to damage that reputation, that relationship.
Did you admit in Mr. Belcher's case that there are times that you choose not to put things in your report that are bad for the defendant?
Your Honor, once again, I think we've gone past the point with the Belcher case.
Well, this has nothing to do with Belcher, I'm just making sure that he knows what case I'm
Listen,
referring to.
I mean, is relevant in terms of how the doctor either documents or doesn't document. And I assume you've got a good faith basis for going forward. Go ahead, I'll overrule the objection.
That was a unique situation because my client wanted, the client wanted to maximize his penalty. And he wanted to keep out of the report anything that would be contrary to his intent. So I was in a position where I would need to speculate, and there's no purpose to speculate. Speculation can come out during examination like this.
Well, during the course of cross-examination, you revealed information about your interview, correct, during that case?
Yes. Yeah.
And when asked why you didn't put it in your report, do you remember giving the answer? I had to make some choices about what to put in and what not to put in, and I thought that that might be prejudicial.
Yes.
So you chose in that case to leave out information that was prejudicial to the defendant.
Yes.
In this particular case, you said you want, and let me ask, in any case, you'd want as much information as possible to make the conclusions you're going to make here, right?
I need sufficient foundation so that I can swear on a Bible and reach a degree of medical certainty.
And it's not like the patient coming to you. In this case, it's a forensic setting in the sense that you're seeking to find the truth, right?
That's correct. It's not my domain to find. I'm not a finder of fact. I'm not finding the truth. I'm conducting a psychiatric study.
And so when you said you gave the questionnaire to the defendant, there's no validity study or no reliability. You have to rely on what he tells you in these symptoms.
Yes.
Right? So when you ask the question, or do you ask the question of him, essentially, do you get very, very focused on horror films, pain or revenge?
Right.
You ask him that question, and he answers no, you accept that as true.
I accept that as his answer.
Okay? Well, is there any validation of this particular document in the sense that this is some sort of nationally known study that you conduct and give to the defendant?
No, that's like what doctors give patients to ask about their symptoms.
Right. I mean, you wouldn't expect somebody who's being assessed for mitigation in a capital murder case to say, yeah, I fantasize about pain and revenge all the time.
Exactly. The intent that a subject has to be factored into the evaluation.
And one of the things you ask is, for each one of these questions, now, past, or not applicable, meaning never, right?
Yes.
And in Mr. Valerio's questionnaire, you'd agree with me that some of these questions about sort of things that's happened in his past, he should have at least checked, well, in the past that might be true, but today it's not true. Would you accept that?
Ideally, every subject would be able to present their biography to me in detail. But my expectations of that is, my expectation is low. I rarely get a really accurate representation of a person's past and current symptoms from the checklist alone. It's just like a screening tool.
You would agree with me that in self-reporting, you have to rely upon the information being provided to you is in fact true.
Yeah, there is no, people don't come with a videotape of their lives. It's an interview-based procedure, much like law.
And much like previously, well, let me ask you this. You said you read the records, correct?
Yes.
And those are the Department of Prison's records, correct?
And yes.
And they're medical records, but they're medical records from the prison, right?
That's right.
You read the, you spent 3 occasions speaking to Mr. Valerio, correct?
Yes.
And you talked to his parents,
Yes.
his stepmom and dad.
Yes.
You didn't talk to his natural mother.
No.
You didn't talk to his sister.
No.
You didn't talk to his stepsister.
No.
When, on direct examination, you provided an example about how a peer had told him that he should write a book about how he was able to do the kind of things that he did. Do you remember talking about that just a minute ago?
Yes, I do.
That's information that was got from Mr. Valerio, correct?
That's right.
You didn't go find the peer and ask him.
No.
You didn't talk to, Mr. Valerio told you that he has a good relationship now with the corrections guards, correct?
I didn't get independent verification of what he told me,
Of any of this.
of any of this, except for the fact that the records that I reviewed was consistent with what he told me and was consistent with what his mother and stepmother and father told me.
And let's talk about that, and I don't need to quibble, and I certainly don't mean to suggest that his mother and father are not being fully accurate with you, but the mom and dad did not report any major problems with Mr. Valerio between ages 13 and 18, right?
No, they represented him as willful, and his father did kick him out of the house as soon as he turned 18.
But not the same description as John Valerio gave you about the types of behaviors he was engaging in between ages 13 and 18,
That's right.
right?
That's right.
And it's not that necessarily mom and dad are not being totally truthful to you, it's their perception and memory that makes a difference, right?
Yes.
And there's not like an empirical data that you can assess whether or not which one is the more accurate. It's perception.
That's right.
Okay? So you talk to Mr. Valerio, and what if I get this correctly, the main thing that seems to suggest to you that your opinion about Mr. Valerio is right is sort of that change in his records, correct?
I wouldn't depend just on the records. I depended on the three venues: the examinations repeated, the collateral interviews, and the records.
Okay. Let's talk about the John Valerio that was younger. As you said, that was different, right?
Yes.
Okay. He engaged in behavior before age 15, and continuing on into adulthood that was criminal or otherwise against the rules. Antisocial behavior.
Yes.
Okay. That behavior at times was impulsive.
Yes.
And that behavior at times, or even based on his own description, he was manipulative, correct?
Yes.
And you said that when he got arrested in 1986, his kind of persona, he took stock of himself, and from there it sort of grew into who he has become today.
That's what I said.
Okay. And while you acknowledge it wasn't an overnight thing, you suggest in your report that he expressed to you remorse for what he had done.
Yes.
John Valerio told you he's remorseful for the crimes he's committed.
For the person that he was.
Did you talk to him at all about the murder in this case?
No.
You never asked him, when you say the term remorse, it's suggestive of his personal behavior, right?
I don't recall the word remorse in my report. Maybe you can point it to me.
Certainly we'll try, but I'm not going to stop it for that. Maybe Mr. Pesci will find the examples we have here. In your report, well, in your interviews with Mr. Valerio, he talked a lot about someone, or he talked at least somewhat about some woman named Elaine.
Yes.
And in the course of, and let me ask you this, your report last night, you also forwarded over all the sort of supporting documents you had, right?
Yes.
The notes that you had taken, right?
Yes.
You agree with me that at least in none of the notes is there any mention of a woman named Kate?
I don't
Or
think
Catherine?
so. No.
Okay. You didn't attempt to contact, well, Elaine is a friend of his for 25 years according to him, correct?
Yes.
You didn't attempt to contact Elaine to see what her impressions were?
No. My role is not that of an investigator. It's a psychiatric examiner.
Right, but there are some empirical things you can look at, right?
There's a wide range of things. Any individual can be studied to an infinite degree.
And you talked about like sort of the child brain, and as you get older, the moral stock comes along. Do I got that right?
There's like a balance between impulsive, emotional areas in the amygdala and the executive area, the frontal lobe.
And I don't mean to make fun of this, but I mean, there's a lot of studies that suggest what every parent of a teenager knows, which is teenagers make bad decisions, young adults make better ones, and older adults make even better ones.
Yes.
Right? I mean, that's
Bottom
essentially
line.
the concept.
Yes, yes.
But the core morality itself is not necessarily a product of your teenage years, is it?
No,
Right?
that's right.
Who you are is, you might make bad decisions, correct?
Yes, yes,
You might make poor decisions.
yes,
You may not reflect upon how your actions are affecting other people, correct?
that's right.
But at the end of the day, you'd agree with me, evil's still evil. There's some people in this world who enjoy the infliction of pain and violence on people.
Yes,
You did not receive any of the records of this particular case, correct?
other than the records that I referenced already, no.
You didn't receive the officer's report that described the crime that John Valerio is here for, correct?
That's correct.
You're not able to provide an opinion that somehow that crime was impulsive in any manner.
No, I can't judge that crime.
You don't know anything about it.
That's correct.
You don't know anything about the underlying facts of the battery with a deadly weapon conviction that he had.
No,
You don't know anything about the underlying facts of the robbery that he was convicted of.
no.
The only thing you know is what John Valerio told you, what the parents told you, and what you saw on the records.
That's right.
Now, your notice of excerpt in this case says that you conducted psychological testing, or that you would be testifying to psychological testing. Have we covered all the psychological testing that you did of John Valerio here?
I'm not a psychologist. I do the psychiatric examination.
Well,
It often happens that the requester confuses the two. I don't perform tests. I did the questionnaire and the examination and evaluated the records. If somebody needs testing, I'll order it.
Right. You have the ability to order it, meaning you have the ability to work with a psychologist to do testing, correct?
Or a radiologist, or any of the medical tests I can order, yes.
But in the psychological field, I mean, obviously there's medical causes of particular problem, but in the psychological field, there are psychologists who conduct the testing along with psychiatrists who are the medical doctors, correct?
That's right.
All right? And it's often that you work hand in hand with those individuals.
Me personally,
Well, or any psychologist.
some psychiatrists rely on psychologists for diagnosis more than others.
So when I was looking through your notes the other night, I saw that there is a note that's dated May 5th of 2015. Do you have that in front of you?
May 25th?
May 5th of 2015.
The file label might be different than the content label.
I mean, I wrote.
Make sure he knows what you're showing him. Yes, you may approach.
All right, so let me show you. This is something that was received from counsel.
Yes,
Did you write that?
yes,
Okay, those are your notes?
yes.
Is that based upon, well, let me ask you this. It says in here, he was initially downplaying drugs. He was leading a drug-oriented lifestyle which might mitigate.
Yes.
What are those notes about?
I think this was the initial assignment, the first contact that I received, probably a phone call, and I took brief notes on it.
The next line is MMPI-2 to show no sociopathy.
Yes,
What is the MMPI-2?
it's a personality test
And what is that personality test used for?
to issue a diagnosis, a diagnostic theory.
And unlike your tests that you put out, or the questionnaire you gave us, there is a validity scale to that, correct?
Yes,
And so, lots of people use this test, the MMPI, right? It's one of the worst.
it's a national standard for psychologists,
You know, people use it in the forensic field, correct?
psychologists mostly.
Walmart or someone else, employers might give it to their employees, for God's sake. I mean, this is something that's widely used.
More in the past than present, yes.
And when we talk about a validity scale, or a reliability scale, has the ability to see if someone is not answering truthfully.
On the test only,
It has a malingering score.
for the test itself. But it doesn't give you a diagnosis that a person is a liar or a malingerer. It just tests the validity of whether the person is answering the questions in a way that people who aren't lying on it answer.
So if you gave John Valerio this test, or a psychologist in your employee or at your direction gave him this test, we'd have a profile and we would then know whether or not there is a suggestion that he is trying to beat the tester.
Beat the test, yes.
And then the note says MMPI to show no sociopathy. So you could have given him an MMPI, and if it showed no sociopathy and it showed that he wasn't malingering, it would be evidence, empirical evidence, that he wasn't a sociopath.
Well, the diagnostic manual doesn't require any testing to diagnose sociopathy. So this was, I don't know whether this was a note that I took about my thoughts or whether this is something that the attorneys were brainstorming about.
You chose not to give him a test that could be validated about whether or not he's being honest in
Well,
his
there
assessment.
are 10,000 tests I could order. I would only order them if there was a reason. They call it a differential diagnosis. If you're uncertain whether it's one thing or another, is it thyroid or is it, testosterone, is that what's causing the problem? Then you order a test to validate or to rule out your hypothesis. So there's no reason to run the MMPI.
And you're comfortable sitting up there based upon 3 interviews with Mr. Valerio and the story he told you and the fact that the records seem to suggest that his criminality end, you're comfortable with, he must have grown out of the problems he had.
I'm more than comfortable. I have a medically certain opinion because the records would be riddled with violations if he had sociopathy. It is an appetite that can't be controlled. It's impulsivity, there's a thrill that people get by taking risks, there's a sadism involved in sociopathy, and there's just nothing in the records like that. Now, if he portrayed himself as a moral and religious, if he told the story that he was one way and the records read something else, I couldn't conclude that he was right and the records were wrong.
One of the definitions of a sociopath, psychopath is in the same name, correct?
Yes.
Antisocial personality disorder,
All the same.
right? And Mr. Valerio could have very well qualified for that at age 25, but nobody assessed him for it, right?
Well, you could say he had antisocial behaviors then, but if you predicted that he had an antisocial personality, the history as it unfolded would contradict that finding. It would have been a poor prediction.
How many things do you have to do? How many years do you have to engage in conduct before you say, this guy's a sociopath?
Yeah, the guidance is persistent pattern. And incidents in 1992, 1994, 1998, and 2000, and none since, in my clinical judgment, doesn't represent a persistent pattern.
Okay, well let me ask you this. What about 1983 and then going to prison and within 1 year of getting out in 1986, another incident where he attacks a woman, gets out on bail, 30 days later, commits the crime we're here for, goes to prison and spends the next 12 years getting violations. You don't think that's a persistent pattern of antisocial behavior, doctor?
As it turns out, because it's a lifelong condition, he has not had that pattern lifelong. So those would be incidents of antisocial behavior, and the manual makes it clear to differentiate between antisocial behavior and behavior that comes out of circumstances and situations. For instance, somebody might steal because their family's hungry. The manual says that doesn't count against a person for an antisocial personality disorder. Drug-seeking behavior, plus the behaviors that come out of needing drugs, that may not be considered sociopathy. That's born out of the addiction itself and doesn't represent a corruption of the character. The character doesn't correct in 2000 and then stay corrected thereafter. If it does, then they still don't deserve the diagnosis.
Doctor, and you mentioned and you sort of say that these violations are they're not major violations. It's sort of what you suggested.
I didn't say that. I said it doesn't represent the persistent pattern, which is the language in the manual.
So, when you were talking about them, first let's talk about the radio antenna. Mr. Valerio explained to you it was a radio antenna that was in his cell, correct?
Yeah, either radio or television.
And in the records, it wasn't like the antenna was still attached to the radio, right?
No, and it was hidden in the window frame, and there was mention, somebody interpreted that as the potential to be sharpened into a weapon.
Well, didn't the record say an informant said Mr. Valerio was going to use it as a shank?
It's an informant, yes.
And then he went into administrative segregation for that behavior, correct?
Yes.
And let's talk, administrative segregation is like what they call the hole of the prison, right?
I guess.
Right? It's deprivation of contact with other human beings.
They're isolated as a punishment, yes.
That's a pretty psychiatrically painful behavior to isolate a human being for a long period of time.
It's not painful, it's not a punishment.
Right. In fact, it's so painful that after 15 days, they have to do some sort of review, correct?
I'm not aware of prison procedures.
The records reflect that Mr. Valerio spent substantial periods of his time in the hole between 1996 and 2000. Would you agree with that?
I don't know what substantial means. I know there were repeated violations, and they got judged in consequence for those that he was found guilty.
Didn't you put an addendum on your report where you listed out every time he was in the hole?
I'm not sure I used the word whole. It was excerpting from the records.
Page 30? Page 30, Counsel.
Page 30?
I believe he was referring that to Mr. Picard. We'll come back to you after yes, here in a second.
He was, at least according to the chart you made, he was in segregation in January of 1997, correct?
What page are you on?
Page 30. The report I was provided.
Yes.
He was then put back in segregation March of 1997 through May of 1997, correct?
I see what you're saying. I don't think this is so much a log of segregation as it's from the medical. These are called segregation rounds. So I can presume that that means any entry here was made from officers who were going around and checking on him. So if that presumption is correct, then I will endorse yes to every question that you asked me.
When someone is in administrative segregation because of the psychological punishment that's going on, there's a concern they may do something to themselves.
Well, as a consequence, I don't think that there was any concern about self-injury.
Well, as a general sense, as the prison, there's medical records that have the prison guard has to check off that he's checked every so often on the prisoner,
Yeah,
correct?
yes, for suicidal watch.
Yes.
Yes.
And that's the medical records here. It's not that there's any indication he was suicidal, but it's just a procedure you see in those medical records. Would you agree with that?
I think so, yes.
So then, after May of 1997, he goes back in June of 1997 to November of 1997.
Yes,
And Mr. Valerio is 32 years old at this point.
yes,
Then he's back in May of 1998, correct? And I
Yes.
think you're slightly out of order here because the one before that would be February of 1998 to April 28th of 1998, correct?
yes,
And then just 3 days later, he goes back in on May 1st to May 5th, 1998, correct?
yes,
And then he goes in on October of 1999 to March of 2001.
Yes, that's what this chart indicates. I just can't say that I know for sure that he was in there for over a year based on this record, but maybe he was.
You don't leave open the possibility that maybe the desire not to have that psychological punishment, or whatever term you use, is the reason why he amended his behavior?
Yes, definitely.
Could there be other reasons other than his internal moral self turned better for the change in his behavior?
Well, people who are reasonable start to avert punishment as they mature because they have long-range thinking. They know that they'll face consequences for their behavior, and then eventually they self-correct. The same thing with children when you're raising them. They need to be corrected and place limits on them until they learn to always do, to do the right thing more often. So one is consequences. The other is internal moral development. A person wants to do the right thing because they feel better about themselves when they do the right thing. And the third would be reward. So avoidance of punishment, characterological improvement, and third is anticipation of reward.
Anticipation of reward, right?
Yes.
Anticipation of reward. For example, are you aware that this hearing was ordered in 2002?
No.
Anticipation of reward, what you're saying is there's a logical connection between the behavior engaged in and the knowledge of what the result's going to be, correct?
If a person has that capacity, it speaks in favor of their character. Some people are so impulsive and driven by adverse desire that they can't long-range plan, they can't adhere to their commitments to themselves or anybody else.
And if Mr. Valerio was that impulsive, he probably couldn't control himself during the ensuing 15 or 17 years, correct?
I would say the record doesn't show a persistent pattern, which is, if it was weekly, daily, monthly, I'd be more apt to agree with you, but it wasn't.
Impulsivity, right?
Yeah, impulsivity and violation of rules, violation of the basic rights of others, all the criteria. But what we have here is a collection of incidents, and we have punishments, and then in the last 17 years, nothing, which supports the conclusion that I reached that he's developed a moral strength and the ability to self-regulate, to think ahead and have long-range planning, even if it's all for a hearing that's going to occur 15 years later.
So what you're saying is really just comes down to that. That's the only fact really that you're considering.
Well, there's quite a bit of common sense in psychiatry. I mean, we use other terms. We like to look at the science, for instance, brain development that correlates with the capacity to withhold, impulses. But
So
if something doesn't make sense, then psychiatry, is not helpful.
So essentially, yes, then essentially that void in the records is enough to convince you by itself that John Valerio wasn't just manipulating you by telling you the story that any 10-year-old could have come up with for changing his life in prison.
Well, it's not as simple as you say. It's not like one data point makes the diagnosis. The way he described his life and his reactions to certain life events and his examination, it just was consistent all the way through. This man tends to push down negative feelings. That's the profile of somebody who swallows their emotions like an addict. I think he has a core addictive tendency. He presents the best of himself and not the worst.
My only question to you, Doc,
It's
is
just that the records support what he said, so that's
that data point
validation.
validated for you that he's just not telling you some story.
Well, again, I think that any psychiatrist who's following the manual would reach the same conclusion. There was no persistent pattern of antisocial behavior.
Thank you, Doctor.
All right, redirect.
Yes. Dr. Reitman, you were asked at the beginning of the cross of the idea of outgrowing conduct. That is people get over, they outgrow it.
Yes,
Isn't that what we call maturing?
yes,
Isn't that what we hope people will do?
yes,
And the problem is that people who don't outgrow that continue to have problems.
yes,
So when you said that a person is, that Mr. Valerio was outgrowing and you agreed to that, that's exactly what you would expect, isn't it?
that's what we would hope for. Some people don't. The purpose of correctional systems is rehabilitation. So you form really strong limits to give a person the feedback right away when they're doing something wrong. And that gives it almost like an experiment. They can run it over and over again. And if they keep making the wrong decisions, they get a chance to sit back and say, well, this isn't worth it, I'm gonna correct it. So a little bit like the sticks on the side of a tree, before it's strong enough in its core, you need structure. Kids need structure, he didn't get enough. He got his structure later, I think it was part of what helped rehabilitate.
And so the point is that what he is going through is what we would hope a person would go through.
Yes,
We would, as the state put it, that the people outgrow things, if you will,
yes,
even bad things.
yes,
And after 31 years, Johnny Valerio appears, based on your professional opinion, to have matured.
yes.
And when you were looking at these records that you put in the back of there on page 30, let's just go to them so we can give an understanding of what the record was. In there, you there?
Segregation rounds, yes.
All right, well, let's go to the first one of it. Those were medical records you were looking at, correct?
Yeah, these would be medical records that were done in segregation.
Well, that was called segregation round.
Yes,
You don't know where he was or what was happening, do you?
no,
So when the state was trying to imply that over 12 years he was in segregation, that's not correct, is it?
I don't really know. I couldn't tell whether this represented what the attorney said, the whole, whether it was punitive or whether it was part of his stringent conditions of confinement.
And a person who would come in, for example, a warden who has reviewed these same records, if he thought someone had been in the hole for 12 years, he probably would have mentioned that, wouldn't he?
I don't know. I do know that it's so peculiar based on my examination and reading the records that he would be in punitive isolation from 1999 to 2001 for a marijuana violation.
And let's look into the first, in page 32. Okay?
Yes,
And the notation that you read was from medical records? Is
yes,
that correct? And it indicated that they were doing their evaluations and there were no major conditions in his mental condition.
that's correct.
And then further down in the next one, this is the jail now, this is the prison records. They put down, if you could look, no indication of significant problems.
That's correct.
And they went down to medical distress, no indications of significant problems, right?
That's right.
Then let's just go down to the last one, which was 97,
Yes,
which was over 20 years ago.
yes.
20 years is a long time, isn't it?
It's longer.
And what they said in the record 20 years ago, this is the last one they were talking about here, was they assessed them for depression, trauma, manic behavior, orientation, and medical dental problems, right?
That's right.
And the jail records that you had referred to said there were no significant problems.
That's right.
So when they were looking where the significant problems of being depressed, they said no.
That's correct.
When they say was there significant problems of being in trauma, they said no.
That's right.
When the jail, the prison, assessed him for, did he have manic behavior? They said no.
That's correct.
Okay? And basically, the last time we're doing this is now like 20 odd years ago.
Yes.
Pretty hard to go 20 years and just pretend, isn't it?
It shows remarkable strength of character to be able to pretend for 20 years.
You don't generally find that, do you?
No.
And so what you're doing as the psychiatrist performing your function here is to explain that to the jury, aren't you?
Yes.
You can't fake it for 17 years.
A person with corrupted character, sadism, sociopathy can't make it for 20 years.
Those things come out, don't they?
That's right. Because faking it requires a frontal lobe function that you're able to suppress. An executive, that you remember, well, I'm going to be going to trial in 15 years. And so you have to be able to sustain your commitment that long. That's not typical of the sociopath.
Pretty far-fetched, isn't it?
Yes.
I mean, and you say far-fetched as a psychiatric doctor.
Yeah, I mean, if a resident presented that to me, I would say, you got to go back to the book and look at it.
Now, you were asked about tests like the Minnesota test.
Yeah.
And you said these are things that are used by psychologists.
Yes.
You're a
Or that I can order.
right, but you're a psychiatrist.
Yes.
As a psychiatrist, so being asked, did you do these tests? These are not tests that you would do.
No, the manual doesn't require it, the psychiatric diagnosis doesn't require it, it's an option, not required.
When you say it doesn't require it, what it does, it gives you the option if you think you need it.
That's right. Now, certain diagnoses like IQ or learning disabilities, you must test for those. You can't use patterns, and you can't use the mental status examination. But most other psychiatric diagnoses don't require those. It's the core competency of psychologists. That's how they're trained. They have to rely on their tests to come to conclusions. Psychiatrists or medical doctors, we don't need to do that. Just like I don't need to be able to perform an x-ray. There's no reason I need to know.
All right, and I take it you've been a psychiatrist for how many years?
I graduated medical school in '76.
76? So over that period of time, do you think you have the knowledge and experience and good sense if you think that you need to have a test done to help you, aid you in giving the jury an opinion that you would have enough good sense to order it?
Yes, I have to feel confident to be able to stand by my opinion and show how it fits the diagnostic criteria. And if not, I better order the test because I'd be under pressure and accountable.
And you feel confident in the opinion that you gave?
Oh, yes.
And you don't think it's deficient because some psychologist didn't give a test?
That's right.
Now, within the jail records, there are a lot of things going on, aren't there? The prison records. I mean, there's medical evaluations.
Yes.
There's psychological evaluations.
Yes.
Right? I mean, these are done within the prison.
That's right. It's the diligence, the authority who's responsible for his health and well-being. They must follow licensure and state federal rules. And they have to make sure that their inmates are healthy and safe.
And after a review of those 30 years of those records with what was done by the prison staff, their psychologists, their doctors, their corrections officers, etc., did you find anything that alters your opinion that you gave us today?
No.
Now, one of the things you were asked was, well, you didn't go back and look at the incident here,
That's right.
at the facts of it,
That's right.
right? And I thought what you did say, let me just get again, You were told by the attorneys that that wasn't relevant to what we wanted you to do.
That's right, that part of the trial was over.
There's nothing that you're going to be able to say about that we're going to be able to present or not present.
That's right.
So what we wanted you to do was look at Johnny Valerio at 50 and tell these people what it was that you think, based upon your 30-odd years of experience as a medical doctor and as a psychiatric physician.
Yes. And not just the experience, but my obligation to adhere to the method of core competency of psychiatry.
And what you said was that you think he is now a pro-social individual,
Yes,
and that's a positive.
yes.
And that's what you would hope for.
That's what we all hope for.
And that's what you're telling this jury
Yes.
that we now have today.
That's right.
Thank you.
All right, Reed Cross.
Just briefly, I don't want to quibble with you, but you suggested that maybe your notations weren't accurate as to the time he's been in administrative segregation on redirect, correct?
The meaning of segregation grounds, I don't know what that reference is.
Well, also in those records, there's a notification they give the defendant every time that he's going to be punished this way, correct?
I think there were findings of hearings and violations and consequences. Is that what you're referring to?
Well, you also list out a number of these in your report as well, in page, that's a pretty long one. Page 25 is the end of it, because they're in reverse chronological order, but,
Page 25?
yeah. And it starts as far back as 1988, where he was given a notice of hearing for a physical assault of another, inflicting, resulting in serious injury, for which he received administrative segregation for.
Is it the last entry, 9/19/88?
Correct.
I don't know if there was a finding. I mean, there were accusations.
Didn't you write in there that the ultimate finding was that this was a group attack? What exactly did you suggest? Do you remember seeing the record that said that this appeared to be a coordinated attack and everybody was being punished for being involved in it?
Mr. Jacobs concluded that it was extremely doubtful that a single inmate carried out the assault on the inmates. Mr. Valerio stated that, while Valerio stated he slept through the incident, the committee members concluded that the accounts of the incident were rehearsed prior to the due process hearing, as there were little discrepancies between each inmate's statements.
And they ultimately concluded it was a coordinated attack upon this individual and punished everybody that got that notice of hearing, correct?
Where does it say that?
Well, it says it in the records. I'm asking you if you remember reading the rest of that, or did you just include the first half in your report?
I included what I thought was salient. I couldn't include everything. But if you represent to me that that was the conclusion, then I go with that.
And you agree with me, a coordinated attack isn't an impulsive behavior, right? It's not impulsive.
Well, I just can't reach a conclusion about what behaviors Mr. Valerio was engaged in.
And I could go through each one of these, but I won't. But I guess my question to you is, you keep saying impulsive behavior, and on redirect, you just said it wouldn't help you to look at the underlying crime. Don't you have to know whether or not this murder was impulsive or not?
On certain assignments, I would need to know. If I was asked the state of mind, was there any insanity factors or state of passion, something along those lines during the guilt phase, absolutely, that'd be my focus. But it would just be a waste of the state's money for me to examine that. Like you said, I'm a mitigation specialist. This is mitigation, that's that.
Maybe I'm confused. Did you not suggest to us that Mr. Valerio was engaged in impulsive behavior until he finally grew up and ultimately started making good decisions, and now that he reflects upon it, he wishes he wasn't so impulsive?
Yeah, but there was no need to study that. I took that for granted, given the number of charges that he had and the nature of the charges.
You wouldn't want to know what each happened on each one of those events to determine if it was impulsive or just downright evil behavior?
When somebody is found to be blind, you don't ask them a million times, can you see this, can you see this? Once he exhibited incidents of impulsive behavior in the past, I accept that, because the next thing to do is look at the mitigation. What has happened since then?
Thank you, Doctor.
Redirect?
Yeah, just quickly, because the state was spending a lot of time on this incident,
Yes.
this last thing. That was 1988.
Yes.
That was 30 years ago.
Yes.
So now we're going back 30 years, closer to the time of the event, right?
Yes.
And so once again, do you think the person that was in 1988 now is the same person here?
No, I don't think he is the same.
And when we go through it, we can pick out something that happened 30 years ago, right?
Yes.
But that doesn't define the whole person, does it?
No.
And when you said that you went through these records, it was the records of 30 years that led you to the conclusion that you've come to.
That's right. A psychiatrist is not necessary to judge an act. That's what the court is for. The facts are what they are. These could be disputed and argued between the parties. The psychiatric value is to address character, state of mind, the presence or absence of psychiatric illness. Not to investigate every nook and cranny of a case or to explain all the facts. Basically, the man that sits there does not have a sociopathic character. He's not at risk to others or himself. The best that I could determine is that he actually makes contributions.
Thank you, Doctor.
Recross?
No, Your
Does any member of the jury have a question for this witness? See one hand? All right, go ahead and write on a clean sheet of paper, put your juror number on it. Anybody else? Oh, there isn't there, somebody else. Okay, good. All right, and be sure to put your juror number on it. Council, why don't you head on up here? All right, some of you asked questions relating to Mr. Valerio's confinement conditions while incarcerated. I don't think Dr. Royman is necessarily in the best position to answer any of those questions. And the parties have agreed they're going to work on the break that we're just about to have and get an agreement as to that should answer most of those questions. However, I do have a couple more for you, Doctor. Can continued use of marijuana increase an individual's level of anger? Why don't you answer the jury, not me?
In a way, yes. Now, marijuana is a poor anger management technique because you don't apply your mind and your maturity to mastering it, to understanding it. Every time you get angry, you run to the marijuana. It's basically like a tranquilizer, like a Xanax. It can delay maturity in that regards. Most people get slightly sedated and more mellow on marijuana, so it's not known to have a greater incidence of anger or violence. In fact, a lot of the adolescents I see use it just to control their anger. So,
And can maturity affect that level of anger?
yes, in fact, most theorists that I agree with is that levels of anger may never go away, but the ability to channel it to understand it, to understand oneself, maturity, that can mitigate it quite a bit. So instead of it peaking and needing to be acted out against, people, they know themselves, they need to play racquetball, they need to compete, they need to make a lot of money to show the other guy. So it's called sublimation. So to redirect the competitive or angry drive and mature it is part of adult adaptation. There are also conditions where the anger is kind of artificial and unnecessary. A person is overly angry, and then with time, people come to realize that it wasn't their mother's fault or something like that, and a lot of the anger goes away. They say it goes to the original feeling, that there might be sadness or vulnerability, and then immediately it goes to anger. I'm not vulnerable, I'm not sad, I'm angry. Somebody made me feel this way, and so they wind up feeling anger, being aware of anger, and acting angry in a defensive manner to protect their pain.
Okay, thank you, Doctor. Does that generate anything further from Dennis?
No, Your Honor.
Anything further from State?
No, Your Honor.
All right. Thank you very much, Doctor, for your testimony today. You're excused. And this is the time we'll take a break. If you can keep it, my understanding is we don't have any other issues, so we should be able to get back into action. So if you would all get back about 25 after, we should be able to get started right at that point in time. While you're out there, don't talk to each other about the case, about anyone that has anything to do with it. Do not talk to anyone else about the case, about anyone that has anything to do with it. Do not let anyone talk to you about the case, about anyone that has anything to do with it. If someone should try to talk to you, please report it to me immediately by contacting Marshall. Do not read any news stories, articles, or listen to any radio or television reports about the case, about anyone that has anything to do with it. Not visit the scene of any of the events mentioned during the case or undertaking investigation, experimentation, or research on your own. This includes use of social media to any way to support the case, or the use of the internet or reference materials to do any investigation or research. And do not begin to form or express any opinion on any subject connected with this case until it is finally submitted to you. Thanks for your attention so far. We'll keep going here in just a few minutes.
All right, jury editing.
All right. Mr. Valerio, it's my understanding that you are going to allocute. Is that correct?
Yes, Your Honor.
All right. We went through the limitation. It's my understanding you're going to do an unsworn allocution. Is that correct?
Yes.
All right. We went through the limitations yesterday with you. Is there anything you need me to re-explain?
No, I believe I understand.
Okay.
You talked about.
All right. And is there anything? Do you feel you've talked about the matter sufficiently with your attorneys?
Yes, sir.
Okay. Again, you have an ability to change your mind up until either Mr. Kitaro or Mr. Erickson calls you to the stand. Do you understand that? Okay. All right. Anything further from counsel for defendant that I need to cover with him?
I don't think so.
No, you're not going to make that.
All right, anything further from the state?
No, Your Honor.
Okay. All right. All right, talk about what you want to,
I typed up what we thought from the
Okay,
jury.
see if you can reach
we
an
can get to an
agreement.
agreement, we'll shoot an email over to Kelly.
all right, I'll be glad to get it. Anything else we need to discuss right now?
No, once the allocation is done, I'm assuming that you guys will settle the instructions and I'll be allowed to leave.
No.
Perfect. Mr. Taro, is that all right?
No.
No? Okay, all right.
Your Honor, I'm trying to protect him from himself.
That's probably true. Good, because I don't know I have room on Sunday, so I'll
All right, is there anything you want me to say to the jury, or do you just want me to ask you to put on your next evidence and ask, and say your,
Well, we thought the court was going to,
Well, I'll say that the defendant has the right, I mean, in reference to Mr. Valerio allocuting. Do you want me to say anything, or you just want me to say, put on your next evidence? And,
What were you going to say?
essentially, if I said anything, it'd be, that, the defendant has the right to appear before you, present an unsworn statement in mitigation of sentencing, including statements of remorse, apology, chagrin, or plans or hopes for the future. Explain that to the jury, or you can just put him up here and we'll let him start talking.
I just thought it is unsworn, but to say it's unsworn seems to highlight something.
But that makes sense why we don't cross it.
Well, no, they can figure that out.
How are they gonna figure that out?
Well, sworn, I'm sure.
I mean, I don't know if the jury's gonna sit there and say, well, because it's not sworn, you don't get a right to cross-examination, that's illegal, legal. I mean, is there something the state, let me just ask you, is there something the state wants me to do?
What you just said a moment ago, because it'll be distinguished from the witness.
I don't know about all that. I've had courts say, counsel, put on your next evidence, and then they say, we're gonna call John Valerio, and then the court asking, will it be sworn or unsworn? And then they say unsworn, and then he has the right to allocute. But
I mean, I'm just asking you, what, is there anything you want me to say, or we just put him on and I say, go ahead, counsel.
Your Honor, our preference is we're putting on the record now, he is just going to allocute, it will be an unsworn statement, he's not going to go into issues related to the crime or anything.
I understand.
Yeah.
So, I mean, when I asked you, you called Mr. Valerio, and you want me to say, is this gonna be sworn or unsworn?
We do not want you to say that. We would just, what we would say is, that Mr. Valerio will now be making a statement to the jury.
Okay, all right, I'll let you do that.
And Your Honor, before we do that, can you read that stipulation that the parties have?
Yeah, I'm gonna read it when they come back in.
Right.
You want me to read it right now?
no,
Just be.
we're reading to the jury. Just make
No,
sure
I
that's
know,
on
but
that.
I mean, if you want me to read it and make sure you're all good with it, I assume that you have reached it.
We send it together. We
Okay.
type it together. We're good.
Okay, yeah, I'll,
And then we have that one additional photograph that we were just going to present so that we can use in closing argument. I don't know.
we'll do that right as soon as.
Did you offer it during witness testimony?
I thought you stipulated to it.
Well, we stipulated
Yeah.
in submission, so
Yeah, no, it was
just mark it as a minute if that's what
Yeah,
we want to do.
just move for it when we get the jury back here. I'd like to have the admission of evidence in front of the jury. Because some of them take notes, and I want them sitting back there going, well, I don't have any note that this was omitted. All right. Anything else we need to discuss?
No.
No, Your Honor.
Okay, let's bring in the jury. All right. Ladies and gentlemen, as I said, there have been some questions that people have asked in reference Mr. Valerio's custodial conditions. It's my understanding this is a stipulation between the parties?
That's correct. It's a stipulation between the parties to be read by the court.
Right.
That is correct.
Okay, so this is a stipulation between the parties, and that's essentially an agreement by the parties as to certain facts, and you can't consider those facts as you feel that the weight involves in your deliberations. And so the parties have stipulated the defendant has been housed in a special unit due to the nature of his conviction. He has never been housed in general population, but has been housed with other inmates in the special unit. Administrative segregation is a punishment which is received for violations of the rules of his housing unit. Okay. And then you had another exhibit you wanted to admit?
Yes, Your Honor. The state requests the admission of.
You're the defense.
I'm sorry. It was based on a stipulation with the state, and that's what was in my mind. The state, I believe, is stipulating along with us to the admission of the defense exhibit H.
Are you stipulating?
We are stipulating.
Okay, and that's exhibit H?
Yes,
All right,
Your Honor.
H will be admitted.
Thank you.
All right, defense presents next evidence.
Your Honor, at this time, John Valerio will make a statement to the jury.
Okay. Valerio, if you come up to stand here. When you get here, go ahead and sit down, or if you can stand, whichever you prefer, and make your statement.
Good afternoon, ladies and
Here, so everyone can, I'm sorry, I want to make sure everyone can hear you. If you can get yourself positioned close to the microphone.
Is that better?
You don't need, I mean, just get it over as close as you can. I'm not trying to get you to slouch or anything, so.
Okay. Good afternoon, ladies and gentlemen of the jury. I wanted to talk to you first and foremost because I wanted to talk to you and look at you and let you hear my voice. And of course, I also thought that if I was sitting in this chair, I would probably want to hear from me. So for those two reasons, I wanted to speak to you. First and foremost, there's not a day that goes by that I'm not remorseful and that I don't think of Miss Blackwell and the things that happened in 1986. I want you to know that. Let's see here. I didn't write a statement because there were a couple of things I wanted to talk about, so please bear with me. My family, Ms. Blackwell and her family were also affected by this, and I want to apologize to them, Ms. Blackwell's friends, my family and friends who have stood by me throughout my incarceration, and I know it hasn't been easy for them. This has been a lot for a lot of people. The last 31 years, I've heard a lot of talk about how I changed or how I haven't changed. There's been discrepancy about that. I feel that I have, specifically the term mentally, physically, and spiritually. Those three elements are essentially what I've taken in one day at a time. And it starts with mentally. The reason it starts with mentally because if you're reading spiritual, if you're concerned about being physical and working out and exercising, if you're not mentally intact, the rest they don't go together. So I started with that. I took an assessment of myself and the things I've done the first 21 years of my life when I first got incarcerated. I think it's probably not very difficult to see that I was a menace. I mean, there's no other way to put it. I made a lot of mistakes. I did some things right, but I did a lot of things wrong. Now, the past 31 years, prison does a lot of things for you. It gives you time to take a look at yourself every day in the mirror when you shave, every time you have a conversation with somebody. And you can either do one of two things. You can either change or you can remain the same. A good friend of mine once told me, her mother actually told her this, and it was a really good quote. She said, my mom used to tell me when you're down on your hands and knees, probably the best thing you can do is pray while you're down there. I did that, and I'm still doing that. I don't run around with a Bible telling everybody how I'm religious or how they need to change their lives, but I do read spiritual material, things that are positive. I make better choices today. And to me, making better choices, things get easier when you make better choices. I mean, rules, various things that I've done throughout my incarceration, they're because of those things. My way of thinking, I try to associate myself with positive people, encouraging people. I try to be encouraging and I try to be positive. And every once in a while I realize that I've made a difference to somebody. I don't do it for self-acknowledgement or a tap on the back, but it does feel good every once in a while when somebody acknowledges that you made a difference for them and to them. I've done that in prison. I've done that with pen friends. I've done that with my parents. They've seen a change in me. I know I've changed, and I haven't changed because I knew this hearing was coming 15 years later. I haven't had a lack of charges for 17 years because I knew that I was going to be in front of you making this statement someday, and well, I want to convince them look at what I've done here. That's not why I changed. I changed because I'm being accountable for all of the things that I've done. I've changed it, as I explained. When I was at my lowest, there was only one way up. I had to make changes. There was a good person in there. Was there a good person the first 25 years? As I said, I did a lot of things right, but I also did a lot of things wrong. So I'm being honest about that. I also wanted to talk about my plans for the future if at any given time I'm ever given the opportunity for a chance at parole. I'll have to continue to do the things I told you about. Because if I don't, that chance will never take place. But I won't do those things to make it to a parole board to please them. I'm going to continue to do those things just like I've continued to do for the past 31 years when I didn't see that there was a chance at a parole board somewhere down the line. Because that's who I am. It's not a facade. There's nothing fake about that. That's just what I'll continue to do. And I'll do my best not to let anybody down. If that ever happens somewhere down the line, I don't know. That's going to be your decision. Okay, so I think I'm going to wrap this up because for the most part, like I said, I wanted you to hear my voice, see my face, and speak to me. I've been over there for a couple of weeks, just taking notes. And I'm going to wrap it up for now. I'm grateful for your patience and understanding. Thank you.
Thank you, Mr. Valerio. All right. Defense may present its next evidence.
Your Honor, the defense has no additional evidence of witnesses.
All right. State have anything further?
Can we have a brief moment?
Excited? All right, go ahead. All right. As said before, does the state have anything in rebuttal?
No, Your Honor.
Ladies and gentlemen, that means that we are at the conclusion, or we have concluded the presentation of evidence to you in this case. The only things that remain is my instructions to you for your use during deliberations and the closing arguments of counsel. We're going to do those on Monday morning, as I mentioned yesterday. I think yesterday I told you that we'd start at 8:30. Just being realistic, I'm guessing the parties will have a half hour of various issues that they're going to want to discuss with me before we get started with the closing. So I'm going to ask you to come start at 9 o'clock. I'll ask you to be here about 8:50 so we can get started around 9, but we'll get started at 9 o'clock on Monday with instructions and the closings, and then at that point in time the case will be given to you for deliberations. So you got a 3-day weekend. You'll be able, if you need to work tomorrow, to go ahead and work or have a weekend. It is 3 days, and again, I want to just sort of emphasize, don't discuss this case with anybody. If you do go into work or you go and hang around with friends or family over the weekend, it's very common for people to ask about what's going on. And I'm ordering you and asking you, don't discuss this matter with anybody. As I've said numerous times, you can say to them that you are a juror in a criminal matter, but don't tell them anything else. And if they should say anything or ask you anything, just say, next time we get together after everything's done, I'll be glad to chat with you, if you want to chat with people. But I can't do it until the case is done. Just tell them that. Tell them you've been ordered by me not to discuss it, but please just don't discuss it with any of your family, friends, or co-workers or anything. We're almost at the end, and once the case we've been discharged, you'll be free to discuss it with whoever you want to. Right now, asking you and ordering you not to discuss this with anybody. And again, Don't go on social media this weekend and mention anything about the case. You're free to go on for any other purpose. But again, don't mention anything about this case in terms of social media. And finally, I know it's always tempting. I mean, I sit there and my oldest daughter was commenting that the internet had ruined debate during conversation, because if anyone wants to know who starred in the movie X, Y, and Z, you just have to type it into Google and you find the answer. So, don't do it. As it relates, I mean, you can do it if you want to find out who's been in a movie, but don't do it in any way in relation to this. I know I keep emphasizing these things, but trust me, over the times that I've been involved in juries, people at times just think, oh, what difference does this make? And, or what's the big deal? I'm telling you, it can be a very big deal. So I'm, again, ordering you, but asking you, please don't go on the internet, or don't look up a dictionary or look up anything in relation to this case. We're trying to have fair proceeding for everybody. If you were to do that, you would implicate the potential fairness of the proceedings. So with those, I'll go through the formal admonitions. Do not talk to each other about this case or about anyone that has anything to do with it until the end of the case, when you go to the jury room to decide on your verdict. Do not talk with anyone else about this case or about anyone that has anything to do with it until the trial is ended and you've been discharged as jurors. Anyone else includes members of your family and your friends. You may tell them that you are a juror in a criminal case, but don't tell them anything else about it until after you've been discharged by myself. Do not let anyone talk to you about the case or about anyone that has anything to do with it. If someone should try to talk to you, please report it to me immediately by contacting the marshal. Do not read any news stories or articles or listen to any radio or television reports about the case or about anyone that has anything to do with it. Do not visit the scene of any of the events mentioned during the case or undertake any investigation, experimentation, or research on your own. This would include use of social media to in any way discuss the case, or the use of the internet or other reference materials to investigate or research the case. And do not begin to form or express any opinion on any subject connected with this case until it is finally submitted to you. It's been a long week. It's been a long 2 weeks, and I really do appreciate your patience. Have a great weekend, and we'll see you Monday morning.
All right, Jury.
All right. You have a good one. All right. If I remember correctly, we really only had instruction. Let's see if you have the original package. Where did I bring it? We had the instruction on depravity of mind, which is page 18, whoops, at issue. I sent out something yesterday to sort of get some general thoughts in terms of my concerns as far as the instruction, and invited any thoughts from any of the parties. The state sent something yesterday in terms of their suggestion as instruction. I appreciate that the defense has argued very effectively that there should be no depravity of mind aggravator presented to the jury in this case. I am going to allow, instruct the jury as to depravity of mind. I do think that the aggravator is sufficient definitions as to what depravity of mind means and what the underlying acts require to have depravity of mind means can be sufficiently specific to stand constitutional scrutiny under Godfrey and subsequent Supreme Court decisions. So with that, let me just ask for comments from any comments from the defense as to either one of the instructions from the court or the state.
Great.
Go ahead.
Yeah, first, the court is correct that we do not believe the depravity of mind instruction using that phrase as broad-based as it is thrown out there has been. Quite truthfully, we gave the court 9 certain cases in this case that say they can't use it. There's that evidence that the court referenced is exactly the same evidence that was introduced in this case that the court did. That has been said when we move to the second point, and that is we filed a motion years ago. I'm not saying I did, the defense had filed a motion that had gone through that said torture and mutilation were not brought forth properly by the state. That was the way we were going on for a number of years until just a few days ago when the court decided they were going to now change that ruling and introduce mutilation, even though the prior court orders said that. That being said, the problem that we have over and above that, because I think that just takes it away here. But the problem that we now come into is with the phrase depravity of mind. In Godfrey, where is it? The Supreme Court of the United States. Huh? I'm sorry, just give me just one sec.
That's okay.
The language in Godfrey that the court struck down was quite truthfully tenfold times more narrow than what the court and the state have somehow set here. Now, so you understand, I have the definition of mutilation is a correct definition. I don't have any problem with mutilation as defined and as we talked about it. But it now comes into when the court and the state have tried to, the vinyl, it's in all that cases, where the court is now saying that there is something called serious and depraved physical abuse. Under Godfrey, that phrase is undefinable. Now, and I think the Supreme Court is recognized that, as I'll say in a minute. The proposed instruction the court gave, which my understanding came from some circuit general instruction, I'm not sure, under federal death penalty with all the things they had there. But that's not the phrase that we have. And our phrase is serious and not or, and depraved physical abuse. Now, I tried to research that, and quite truthfully, that phrase only comes up in Nevada. Now, as this court is aware, we have eliminated the whole depravity of mind aspect of an aggravated statutorily, and quite truthfully, I think we've done it through case law as well as through the court system. So the reading really where, if there is any life, and I don't think there is, after Valerio and Rogers, which was cited before in the Rogers case, being the 2000 15 case, that the only definition you could come up with depravity of mind is saying that depravity of mind is mutilation with the definition. This serious and other physical assault, a depraved physical assault, then requires then a definition of what is depraved. The instruction that is out there doesn't define what depraved is. Remember, going back to Godfrey and then all the case law that we've been cited and then narrowing, it is to narrow it so that we're talking about the worst case. If we look, where is their instruction? It's, every murder will fall within the court's and the state's instruction. Because, or other serious, maybe inflict, where is it? Other serious and depraved physical abuse means a significant or considerable amount of injury or damage to the victim's body. I submit to you every murder inflicts a significant amount of injury because it kills somebody. As a matter of fact, the courts actually used that the definition that they struck down in Godfrey was a much more narrow, and there they said it couldn't. Here, a definition that serious injury or a significant or considerable amount of injury or damage is not a narrowing, it's an expansion that covers every killing there could be.
Well, I mean, does it get limited by the term must be beyond the act of killing itself?
No.
Why not?
Why?
Yeah.
Because then when you go down into your other part of it, it can be before or after death. It doesn't require the consciousness or abuse of the time it was inflicted. And as the Valerio court stated, and as the Rogers court stated, and as the Ybarro court stated, those were all Nevada decisions that went to the Ninth Circuit. They held the opposite. I mean, if there's going to be over our objection on instruction on this, which then the instruction should be exactly what the Nevada Supreme Court said, and that is that mutilations and depravity of mind includes mutilation, and with that definition, yes. Now, what I'd like to do,
the Nevada Supreme Court said, you know, it's torture, mutilation, or other serious and depraved physical abuse beyond the act of killing itself.
now, actually, here's what in State versus Smith, 114 Nevada 33, after Roberts. Let me get the right quote.
Nevada 114 Nevada 33?
114 Nevada 33.
Okay.
Okay? And let me find this is Nevada's. Since Roberts, this court has upheld sentence of death based upon depravity of mind only where there has been evidence of mutilation or of torture. All right? So what they said after Robbins is that what we are talking about then is exactly that. And let me read it again. Since Robbins, this court has upheld sentences of death based upon depravity of mind only when there has been evidence of mutilation or of torture. And then it goes on, depravity of mind is an aggravating circumstance where the murder involves torture of mutilation. Okay? So what we have, even in those cases, is the recognition of not this expansion. Quite truthfully, the Ninth Circuit, also in Rogers and in Ybarra, where it was much more pronounced. You have the quote from the Bible. Well, I'm trying to find, judges, where the Ninth Circuit held of the where they gave us the language that we had what was knocked out in Godfrey. Again, I have 2 cases here, but you have it. Right. And the language is where they had the offense was, and this is what they struck down in Godfrey: outrageously, wantonly, vile, horrible, or inhumane. All right? The point is to find a killing that is vile, inhumane, wanton, all those phrases that are in Godfrey, which are then brought out in Rogers, as well as Valerio, and in Ybarra. Those there are much more narrow than saying that a significant injury is sufficient to have depravity. I mean, if you compare the language of a mutilation as defined, and you compare that with the language of the last part as defined, those phrases are much more narrow, much more limiting than anything that the court has proposed or the state has proposed. Now, once again, as I say, you can find a definition that'll say a serious injury, and you can find, there's a whole bunch of cases out there that use that depraved indifference. But what we have is serious and depraved physical. And as I say, by the time we get to the state, the Smith, the Deutscher, and those cases, all the way up through the Ninth Circuit, we end up with a situation where it has been a very, very narrowing thing. And so our belief is, if over objection you're going to give a depravity of mind, you have to define depravity of mind the way the state Supreme Court did in Smith, which is after Robbins, Deutscher after Robin, and that language of, and we've already knocked torture out, so we left with it as mutilation. Now, we've had discussions back and forth, and I know the court is aware that the review process that may go on when you get into a federal court and state habeas, et cetera, and 2254s and 5s and 6s and how many numbers there are there, when they get up there, they're looking at the language in different ways. And what they say that the analysis is, they said it in Valerio, they said it in Ybarra, and they said it in the Rogers just 2 years ago. We're assuming for purposes of a harmless error. We're assuming for purposes of harmless error analysis that the Robbins definition is proper. Because as the court knows, what they were saying is there a way to uphold the state conviction even if we have if it's harmless error? And so when they go into the language the state has been citing, that was in a harmless error analysis. And for example, in Ybarra, which was interesting, citing the same vile language. There's a big long section of the Nevada instruction that when they went through that, in that case, they said, yeah, that instruction is unconstitutional, it's improper under Godfrey, it's improper under
Well,
Valerio.
the instruction that was given at trial, they said was improper. They
Right, and that-
never ever, the Ninth Circuit in none of those cases you cited has ever said that the Robbins instruction
Right.
is unconstitutional.
No, that's what I'm saying. What they said is they're using a harmless error and saying we don't have to, for the purpose of the harmless error, we don't have to do it. And for example, in Ybarra, they upheld the conviction, saying under a harmless error analysis, the improper instruction, in fact, didn't defeat it, whereas in Valerio and Rogers, based upon the facts in those cases, it in fact did. That's
Right.
the point I'm making. But when you come to State v. Smith, we are there is no definition that you're going to find out there of serious and depraved physical assault. What you came up with the Eighth Circuit, going back, that there was a different sort of section, and it said serious physical. Doesn't say serious and depraved in the conjunction. And so we don't even have anything in Nevada. And then they say all the cases we're dealing with, what we call in the broad, what are still out there in the broad sense of depravity of mind, dealing a torture, mutilation sort of thing. So what I'm saying is, if you're gonna do what you have said you're going to do, which obviously we disagree with, is that the depravity of mind is with the definition of mutilation and beyond the act of killing.
Okay.
The stuff that you've come up with is not out of Nevada. It doesn't use the phrase in Nevada, and in Nevada it is limited to that. And anything else would violate Godfrey. It would be not a narrowing the instruction of a potential death sentence, and it would be an expansion of it, which on its face would then be unconstitutional.
Okay. Let's focus first of all on Smith. I'm sitting here and I have to admit, I'm looking at it. This was never cited to me before. We're looking at it.
Same with me, Your Honor.
I'm sitting here and
As you look at it, I'm looking at it, I just got the cite as you heard it as well, and it says that it requires the inclusion of the mutilation beyond the act of killing itself. That's what Your Honor's instruction has. We are complying with Smith because the instruction indicates that it has to be torture or mutilation beyond the killing itself. So that is not in violation.
I think we're all, we're not in agreement, but we're saying that if we're going to do, they're saying if you're doing it if you're going to do it, Smith says that we can only have torture or mutilation. Torture is not going to be argued, so it's not on the table, so all you can have is mutilation beyond the killing itself. So, what about the remainder of it, which is significant abuse, or significant and depraved physical abuse?
Well, Judge, I apologize because I'm trying to respond to some of what he said too, because there seems to be kind of a stream of language in different areas. And he talks about how Godfrey's saying that we can't have vile.
I'm not worrying about Godfrey right now. I think we can get a definition of depravity of mind that passes Godfrey. I'm concerned about Godfrey, and obviously I want to consider it, but I think we can get past Godfrey. Right now, what I'm concerned about is, do we even need to bother so much more in terms of the issue if Smith is saying to me that depravity of mind can't include significant and depraved physical abuse.
And are you saying that case says that, but it cannot?
Let's go down.
Because I'm trying to track it.
All right.
Because
Let's see. In addition, on remand, the jury was given instruction 11. In order to find torture or mutilation of a victim, you must find that the torture or mutilation beyond the act of killing itself. In order to find depravity of mind, you must find serious and depraved physical abuse beyond the act of killing itself. That's the instruction that the court knows was given to the jury in Smith versus State. The court then says, given the insufficient evidence that the murder of Christie involved torture or mutilation, the trial judge may have implicitly decided that serious and depraved physical abuse involved less physical abuse than torture or mutilation. In any event, the jury was given definitions for torture or mutilation, but given no guidance as to what constitutes serious and depraved physical abuse. This jury instruction is a departure from what this court has previously determined is constitutionally acceptable. So that's where I'm saying, we conclude that the jury instruction on depravity of mind failed to properly channel the jury's discretion in connection with the charges stemming from Christie's death. An aggravating circumstance based upon depravity of mind must include torture or mutilation beyond the act of killing itself. We vacate the sentence of death as Christie and impose a sentence of life in prison without the possibility of parole. So what I'm reading here from the Smith case that the defense has just cited to me
I apologize, it's 114 Nevada 33?
114 Nevada 33.
Okay, thank you.
And I can't, can you see what page that we're talking on here? Page page 38.
Thank you. So then my question really is what is the portion of the instruction that they're seeking to strike?
Well, they're wanting to strike, I mean, essentially, they wanted the instruction to be to establish that the defendant killed the victim with a depraved mind, the state must prove the killing involved mutilation beyond the act of killing itself. Mutilation entails cutting off or permanently destroying a limb or essential part of the body to cut off or radically so as to make imperfect.
That's correct.
Right, but then there's the other serious or physical.
They're saying that Smith says we cannot have any longer that depravity of mind encompasses serious physical or serious and depraved physical abuse, because they're saying that the Supreme Court in Smith said that to have depravity of mind, you got to have either torture or mutilation. You haven't looked at this either?
No, we just cited this right now.
All right, I'm going to let you have, since this is obviously a very key point, I'm going to let you have 5 minutes or so to take a look at it so you aren't sitting here rushing on that point.
Thank you.
We're going to step back and we'll get back together in about 5 minutes after everyone's had a chance to take a look at this.
It's Browning v. State,
Yeah.
120 Nevada, 347 in 2004. In Browning, which involved the depravity of mind death case, the court states that we therefore construe the relevant statute, which is the one we're working under, to require torture, mutilation, or other serious physical abuse, and then beyond the act of killing itself, as a qualifying requirement to an aggravating circumstance based in part upon depravity of mind. So clearly, it's not erroneous to have other serious physical abuse when this court, or the Supreme Court of the state of Nevada, is saying it's required, therefore construe the relevant statute to require. So it does not run afoul of Nevada Supreme Court case law. And what's baffling to me is we're continuing to try to narrow this. That's the state's perspective as far as the serious physical abuse. And a moment ago they were talking about violent, inhumane. The whole problem at Godfrey, the whole problem with depravity of mind in the 80s was it didn't sufficiently narrow. The definition of serious physical abuse that you give, that we propose, narrows because it says it has to be serious physical abuse and it describes what it is. And so we're doing precisely what death penalty case law says, is to narrow those individuals that are facing it. And we're utilizing the very language the state Supreme Court has said is required. And even when you go back to Valerio, if I could for just one moment, I apologize. We talked about the physical abuse that is required. It references more serious physical abuse, torture, or serious physical abuse. That's in Valerio v. Crawford, 306 Fed 3rd, 742. And so this parlance of serious physical abuse is utilized in the very federal case, in this case, the very Valerio decision itself. And so we're not running afoul of federal case law. We're not running afoul of state Supreme Court case law. In fact, we're following it and we're narrowing it, which is why this instruction should be given. Now, if you want to address it, torture, striking torture, I can understand that concept. But as far as the serious physical abuse, we've done nothing wrong. We're following the case law. And it's really, this maintains the defense's opportunity to argue to the jury. It's a question of fact. The state has not proven to you depravity of mind. We've shown to you that it's not. They called their doctor. Each side will make their pitch as to whether it qualifies for depravity of mind or the serious physical abuse. They're not prevented from the defense whatsoever. And we're sufficiently narrow. And interestingly enough, when that quote from Browning is cited to, it cites the head note or the drop-down note as 2 Robins. Judge, I apologize, I don't know what you read, but I'll point you specifically in Valerio v. Crawford, 306, Fed 3rd, 742, around headnote 25 and 26. The court states the prosecutor could still have argued under Robbins for a finding of mutilation, as he did during the actual penalty phase trial, and for a finding of serious physical abuse.
Well, I mean, here's what I'm. In 1990, you have Robbins, which says that depravity of mind means torture, mutilation, or significant or serious and depraved physical abuse beyond the act of killing. So that's the instruction the court gives in 1990 in terms of defining depravity of mind. And Valerio essentially focuses on whether there's a harmless error analysis. It says, assuming that we accept this instruction as being sufficient, does it, was there harmless error? And of course finds that there wasn't harmless error. But what I'm sitting here saying, okay, we have as of 1990 this definition provided by the Supreme Court. Does the Supreme Court, Nevada Supreme Court that is, in 1998, step beyond Robbins and say, well, okay, in terms of depravity of mind, you've got to, we're cutting out depraved, serious and depraved physical abuse and saying it's got to be torture or mutilation. And I realize, that you've got the Browning case, which says that the Robbins instruction is okay, but that's dealing with a trial that occurred in 1988 or 89, I think it was 19. When was it? About 1988. And so, there's a difference between sitting here saying, Robbins' instruction is, saying torture, mutilation, or serious and depraved physical abuse beyond the act of killing is okay, or is sufficiently definite to get past Godfrey. And another thing to say, here's our new definition in Smith versus State of what depravity of mind is, and it doesn't include serious and depraved physical abuse. And that's what you follow the distinction I'm discussing here.
Yes.
Most of these cases, Robbins, most of these cases, Valerio, Ibarra, Rogers, all are sitting here looking at pre-1998 trials and convictions, and the jury instructions they were using at that time, and saying, okay, were these jury instructions sufficiently definite to pass constitutional muster, or we're going to accept or assume for the purposes of this appeal that they're sufficient to pass constitutional muster. But beyond that issue, did the Nevada Supreme Court in 1998 in Smith versus State say and aggravate, that change that and say, okay, if we're going to, be doing retrials on depravity of mind, here's the instruction you need to be using in any retrial. If you're going to be alleging acts and aggravator depravity of mind, and it's going to be either murder or torture or murder beyond the act of killing itself. So that's what I'm pondering and trying to divine at this point in time.
And I think the divination error comes from the 2004 case, because if in fact in Smith in 98 they had made that ruling and changed the law in essence, they wouldn't have stated in 2004 what I just read from Browning. And so Browning clears that up.
Okay, let's see, where are we? The instruction in this case failed to properly define the term depravity of mind. Absent a proper limiting instruction, depravity of mind fails to provide the required constitutional guidance to jurors. Therefore, we construed the relevant statute, former Nevada revised statute 200.033, subsection 8, to require torture, mutilation, or other serious use beyond the act of killing itself. That's a qualifying requirement to the aggravated circumstances based in part upon depravity of mind.
So if in 98 they had departed from what they were previously saying, it would indicate that, and as we said in 1998 in Smith v. State, da-da-da-da-da. And then when you go to Valerio itself, which is 2002, the federal court interpreting the Nevada law does not disavow or cut out serious physical harm. In fact, it speaks about how the prosecutor could still pursue that. There's nothing indicating or adopting the language in 1998 from Smith that in essence I think is an outlier and confusing. I don't think it's really the court's position, but also wouldn't have said what it said in 2004, nor would the federal court interpreting state law have...
Now, see, that, again, all of these cases are looking at pre-1998 jury instruction. Like I said, what we're talking about in all of these cases that you're citing is the Robbins instruction sufficient to avoid a vagueness finding?
And that's,
none of them are talking about, okay, on a retrial,
I agree, Your Honor.
to charge, to allege mutilation, you've got to have X, Y, Z, and that's what I'm concerned with is and whether, and I'm not sure I see Browning, Browning talks in terms of the instruction in this case fails to properly define the term depravity of mind. Absent proper limiting instruction, depravity of mind fails to provide the required constitutional guidance to the juror. We therefore construed the relevant statute. They make reference in the past tense. We construed the relevant statute to require torture, mutilation, or other serious physical abuse beyond the act of killing itself. And it cites Robbins, which is 1990. So, I mean, what it's saying there is, depravity of mind was not sufficient, so we came up with this new definition of what depravity of mind is.
And also, looking at Smith, it is factually looking at the evidence in that case. Given the insufficient evidence that the murder of Christie involved torture and mutilation, the trial judge may have implicitly decided. So, I mean, that's looking at the facts when he came up to its decision.
Well, I mean, it's saying, since the trial judge said there wasn't enough to show murder or to show torture or mutilation, that must mean that the trial judge implicitly thought that serious and depraved physical abuse involved less physical abuse than torture or mutilation. In any event, the jury was given the definition for torture and mutilation, but given no guidance as to what constitutes serious and depraved physical abuse. This jury instruction is a departure from what this court has previously deemed as constitutionally acceptable.
And they said it's because it's not channeling. So I don't understand how this language isn't properly channeling.
Well,
Narrow.
I do think that I think you can define something under Robbins' definition, that would probably pass constitutional muster. What I'm asking now, or dealing with now, is defense's argument that in Smith, the Nevada Supreme Court said an aggravating circumstance based upon depravity must include torture or mutilation.
But it's indicating there was given no guidance as to what constitutes serious and depraved physical abuse.
Yeah.
We're giving them guidance. That's what the instruction's doing.
No, I understand that, but I guess as I sit here, the court isn't saying, you know, the court isn't saying they did a good or the judge did a good job on giving the torture and mutilation instructions, and it would have been, you know, and if the just said, you know, given some more, you know, definition or guidance on the serious and depraved physical abuse, that would have been, it could have worked, but the judge didn't. They just say, an aggravated circumstance based upon depravity of mind must include torture or mutilation beyond the act of killing itself. And then you go back to the other language earlier in the decision.
I think what it's saying is that because it didn't have the very thing that we're saying to put in, it was not appropriate. Because it says, but given no guidance as to what constitutes serious and depraved physical abuse. That's the problem. It was in the vacuum, and you look at the instruction, it says, in order to find depravity of mind, you must find serious and depraved physical abuse beyond the act of killing itself. That's the problem. It doesn't have what we have. We're saying this is what serious physical abuse is. It's not saying you can't say serious physical abuse. It's that you have to drill it down and explain what it is.
You cited me some earlier language in that decision. Where was that?
In Smith?
Yeah, Smith. Saying our previous decisions have always said it's got to be.
Yeah.
Okay, I found it, page 37.
Since Robin, this court has upheld sentence of death based on depravity only when there's been mutilation and or torture, citing Jones.
And Your Honor, one thing I would add into this intellectual discussion is the fact that we are dealing now, in 2017, with a statutory structure where depravity of mind no longer exists. And I think that's in large part because of all of this confusion of 25, 30 years of cases back and forth trying to apply this very ambiguous phrase of depravity of mind.
Yeah, let me just, let me, if I could, give you the definition they were using that was struck down in 2015 in Rogers, which is much more narrow. There they said they cite depravity is characterized by an inherent deficiency of moral sense and rectitude, sense of evil, corrupt, and perverted intent, which is devoid of regard for human dignity, which is indifferent to human life. It is a state of mind outrageously wanton, vile, horrible, or inhuman. The Ninth Circuit in 2015 said that's not narrow enough, going back to Godfrey, this is in the Rogers on depravity of mind, because they said, look, a year before this, the Supreme Court had declared it out, and then they went on. The court ruled the instruction vague, absolutely, because the period of ordinary sensibility characterized almost every murder is outrageous or wanton. So what I'm saying is, you know, we're trying to argue what was supposed to be, that was never, that 31 years later now, is a totally different definition that was ever submitted way back when, and that's why you're doing it over our objection of mutilation, but that's what I think it says, since Robbins.
It says responding to the Rogers language that was just cited, that doesn't show up in the instruction we given you. What he just read.
No, I'm not,
And then going back to Smith, what they pointed to, where you just asked them to read, it says, since Robbins, this court has upheld sentence of death based on depravity of mind only, where there has been evidence of mutilation or torture. We're speaking of mutilation. Serious physical evidence is mutilation. It doesn't say, you can't say serious physical evidence. It goes on. Accordingly, as is construed by this court, depravity of mind is an aggravator circumstances where the murder involves torture or mutilation. That's what we're saying, mutilation. And there was insufficient evidence in that particular case. There's nothing in this language that says you can't use the word serious physical abuse. And in fact, I go again to the point where it says because there was no guidance of what serious and depraved physical abuse is. That's the problem with the instruction in Smith. Not that it says serious physical abuse, but that it's not giving guidance. And we've given the guidance. We've given the guidance based on the case law that you pointed us to.
I agree, I think you can give guidance on it, but I guess what I'm wondering, my issue is, does Smith say
What it says.
that, does Smith say that depravity of mind now has to include, it says depravity must include torture or mutilation. And it seems to suggest that if it's not torture or mutilation and you're talking about other physical abuse, then you must be talking about something less than torture or mutilation. And that seems to be suggested is not sufficient under Smith v. State. All right, I'm going to look at it tonight. I'll issue a ruling tomorrow.
Okay.
If you want to submit, and again, counsel, I know you sort of got hit with this one out of the blue, so I mean, if you want to submit anything further to me in terms of the, I'm going to take a look at the history of Smith
I appreciate that.
and a little bit further, if you want to submit something further. But I am, as I said, I'm not, Rogers, Ibarra, all of these, none of them, they're all looking at the Robbins definition because that was what was at issue at the time of all the,
Correct.
of all of this. But what I'm looking at is does Smith announce a new rule beyond Robbins that if you're going to do depravity of mind, post 1998, it's got to be either mutilation or torture.
But could we assume that what you had read is the instruction that you're considering able to go over the weekend? Do you want us to,
Okay.
you want us to write one the way you did?
No, I'll send out the instruction
Okay.
tomorrow and know whatever I'm going to do. But I mean,
Okay.
if I decide that it has to be torture or mutilation, and I indicate I'm excluding torture, the instruction is going to be to establish the defendant killed the victim with a depraved mind, the state must prove the killing involved mutilation beyond the act of killing itself. Mutilation entails cutting off or permanently destroying a limb or essential part of the body, or to cut off or alter radically so as to make it imperfect.
Okay.
Is that what you're?
Yes.
Okay, that's what you're asking.
Okay.
If I decide physical abuse, serious and depraved physical abuse can go to the jury. I'm going to indicate, the people say, to establish the defendant has killed the victim with a depraved mind, the state must prove the killing involved either mutilation or serious and depraved physical abuse to the victim beyond the act of killing itself. Mutilation entails cutting off or permanently destroying a limb or essential part of the body, or to cut off or alter radically so as to make imperfect. Serious and depraved physical abuse means that the defendant relished the killing or showed indifference to the suffering of the victim as evidenced by significant or considerable amount of injury or damage to the victim's body.
And the state would just ask, if you do that fashion, we'd ask that the language that talks about how it can be pre or post mortem.
Okay, all right. And then, yeah, I'd include the language that we should read post-mortem. All right, do you want to get together sometime tomorrow to finalize that, or do you want me just to issue a minute order? What do you want to do?
Whatever you want.
Whatever's easiest for you, Tom. If you want to do it, get together with.
I would be able to do it early in the morning. I have federal hearings at 10 and 2 tomorrow.
All right, well, my hearing at 9 got moved to 10.
If
I
we
mean,
do
if
this,
you want to just send it out, I mean, I think the battle is joined.
sorry, I'm just waiting.
Well, I'm sorry, what did you say you could do it yesterday, tomorrow, Mr. Erickson?
Your Honor, I could do it at 8:30. I have a 10 o'clock
Okay,
hearing.
how long is that going to go?
The 10 o'clock hearing?
Yeah.
I really do not know. The client is very difficult, and the last time we were in court was about an hour and a half.
All right, well, sorry,
So,
what's the maximum that hearing should go?
hour and a half.
All right, I know it's Friday, so everybody wants to get out of here. Do you want, let's
Just whatever you want. We'll
let's
be
just
here
do
when
it,
you
let's
want.
get together at 12, and we'll finalize this instruction. Let me just ask, and let's try to minimize, and I think we all were here late last night, I don't want to keep my staff late. What's your thoughts in terms of the special verdict form as modified by defendants?
I apologize, I put that away, I thought we were done.
It's this one here.
I'm sorry. Which one? There are two special verdict forms that I've been given, one that has red and one that doesn't.
Well, that's where I've got one that has red.
Starting
That's
with the-
apparently, my understanding is your form, and the red is their modifications to your form.
Yes, and then the non-red one is.
Is their form altogether.
Correct, and that's talking about a non-unanimous verdict, and I don't think we should be having some sort of a verdict in a non-unanimous situation. We're telling them,
We'll go to that one. I want to know first what about your form.
you want to know about my form?
I mean, are you okay with the,
As far as on page 1 of the defense proposed, which has the red lining,
yeah,
I don't have a problem with where it says previously put in there. I don't know why striking 1988 is a problem, considering the fact that we told this jury repeatedly.
well, I know I told it, but I mean, I don't care, we can strike it.
And then as far as page 3, I don't know what their proposed mitigators are yet.
I'm going to say, I assume you have more than the youth of defendant John Valerio, who was 21 years of age at the time of the crime.
Yes, Your Honor. Now that all the evidence has been presented in through Dr. Reutemann, and we have what the record is, we will fill in quite a few, and they will be ones that we believe the evidence showed as far as.
Can you get that listed, get that fill in by noon tomorrow?
Yes, Your Honor.
Okay, that way tomorrow, like I said, I want to have, when we get done at noon tomorrow, for better or for worse, I want us to have the finalized set of jury instructions and finalized verdict forms so that we can on Monday get started at 9 and get this to the jury.
Okay, one other thing, Your Honor, Mr. Mary, well, Mr. Valerio will be here, but I don't think we need to dress him out.
Yeah, I don't think we need to dress it
Okay,
down.
so, he'd like to be here, but you don't need to dress him out.
On Monday, be at,
No,
Tomorrow at noon.
Oh,
Tomorrow,
Oh, so tomorrow?
at noon.
At noon?
Yeah,
All right, guys, just wanted
all right, okay, so anyway, assuming you don't have any issue with their mitigating factor, how it works, I don't think you will, but, so,
Page 5.
page 5,
No objection to the proposed striking that's in red as to count 3, on page 10, lines 10, 14.
okay.
The strenuous objective, page 6.
What do we do with page 6?
There's nothing on there. He's got a page with nothing on it. So just need.
Oh, okay, all right. I was like, oh. All right,
Page 7.
all right, we'll strike that blank page.
Page 7, no objection to where they've added in mitigators on line 1. Again, I don't see the problem with 1988 being in there. They've said consideration of parole in line 6, no objection. Line 11, no objection. Line 15, our earlier comment. Line 18, no objection.
All right, so this sounds like, at least as to your form, we've got the modifications and we're good to go on that.
Yeah.
We'll get the other mitigators for you tomorrow in this. So go ahead and pump them in and have it at 12 and we will finalize that.
Okay, so just so I'm clear, all of these proposed changes are...
Yep, everything's good.
Okay.
I'm good with it too. All right, now, the other form.
This is asking for the very thing we're not supposed to do, which is asking what they're counting. It's either you're unanimous or you're not.
What's the purpose? Let's start out with the easiest question. What's the purpose of this?
Well, the purpose is a statute that said, obviously, if jury comes back, no death. That there's unanimous no death, and no matter what happens, there can't be death.
Right.
All right, you can't go back and have a new penalty, or you could not order a new penalty with death. But the issue comes out is what if the jury comes back, and that's what we're trying to find out, what if the jury comes back 11-1 for life with the possibility of parole, 11 for that and 1 against it. Then we're faced with a statute that we mentioned a few days ago, where the statute indicates, I don't think it's constitutional under that situation, that's why we're trying to do it, would say, oh, you have to give them life without, when the jury 11-1 was for life with. That is to say, it takes the discretion away from everyone under that statute. Now, the problem that comes, obviously, with counts, normally you don't have that problem in whether there's going to be a new trial or not. You only have it in this particular situation when you're dealing with a death penalty situation. And we have the statute that is out there, as I say, that it says if it's hung, it doesn't say how it doesn't say hung. It's implied that if it's hung, not death, but and there you go to life without. We're saying that by having the count, we know, one, can you go back to a new penalty and seek death? Because that you could say that. I'm going to give a new penalty like what happened here. But you couldn't seek death if you said we're going to have a new penalty if the count is 12-0 against death or split down. So it's the issue of what's going to happen if that happens. And the only way an appellate court would ever be able to really review it and look at it is with a special verdict with a count. Now the statute, there's a case that says they didn't have to do a count. It didn't say it was prohibited of a count. It was, I can't remember the case, was a count before. But that's what I say. They come back 11-1 for life with the positive parole, one person life without, under that statute, without knowing what that count is, do you send it back to for a new death penalty, when in fact it was a unanimous against death?
But doesn't, I mean, the special verdict form says, by checking yes or no as to whether the jury unanimously finds that the state has proven any aggravating circumstance. So if it checks yes, that means they found it unanimously. If they check no, it means that they hung on it.
No, but it's with I'm sorry, I thought Tom had, but I'm talking about the hung situation. If they come back hung, they say we can't come up with a decision, then we have to know the count. Because the count, if they found 12-0 against death, you can't go back for death. But if you don't know the count, then it throws it back again.
Because if they come back hung, they're hung. There is no verdict.
Oh, but there
The
is a
statute.
verdict. There is a verdict of one of the three. You could have 11-1 without a death verdict. And if it comes back that you don't have a death, if they were not unanimous for death, then you cannot seek death again.
The verdict form that you have, that you were just speaking of, does that very issue. It goes through the first issue is, did they find that the aggravation exists beyond reasonable doubt? And then it goes through whatever mitigators, and then they have the choice. There's 4 forms total. The first one says, having found that the mitigation does not outweigh. Then we know what their position is. If they hang, at that point, death is still owed. The other thing is, the statute they're referring to is if a jury hangs in the penalty, it is not automatically life without. It provides you with the discretion to impanel another jury for death, or you can say life without. So you don't need some sort of count as to what happened to
All
make
right,
that
well,
determination.
I'm not inclined to give the special verdict form. I think, I think the state's right, it is what it is. If they can't reach a verdict, then the statute is what it is. But if you have some case law out there, I'll be glad, like I was glad to look at Smith versus State today. If you got something out there, fine, but as a general principle, these aren't the only death penalty cases that are out there. So absent seeing something out there where somebody says, this is what should be done for some reason similar to what we're talking about here in Nevada, then I'm not inclined to do the special verdict of giving a count as to the jury's verdict.
And just for clarification, the special verdict, the short one, it would be our position that would only be submitted to the jury if they came back, were declared to be a hung jury, then it would be requested to be presented that way.
All right, I'm not inclined to go down that route, but I am inclined to look at some cases out there that have done this and see if it's applicable to our situation here. But other than that, I'm not inclined to do that. All right.
Your Honor, and I apologize, I just looked at my calendar because I've been in court all afternoon. The issue with my hearings tomorrow, the one at 2 o'clock is a federal sentencing. I looked to see when my staff have been able to schedule me. I'm scheduled to be meeting with my client's family at 1 o'clock over in court to finalize things with them because of just the schedule I've had with this trial. I'm not in a position to be here at noon. I don't know if it works to be here at 8 or 8:30. I can do it early.
You need to be over there at 10?
Right, I've got 2 hearings. I've got one, yes, but one at 10. That one, if I leave here at 9:45, I just need to get over there and be in court by 10 minutes. There's no pre-work that has to be done now.
All right, all right, let's plan on 9 o'clock. Can you get him here at 9 o'clock tomorrow?
I can put it on the calendar.
Okay, let's do it at 9.
Your Honor, Mr. Blair, if it's going to be set for 9 o'clock, then he has to be excused for the decision.
Are you sure, Mr. Valerio?
Yes, Your Honor, I mean, I trust my attorneys and I'm sure they'll litigate, unless the jury's here, I choose not to be here in the morning. I'll be here Monday morning if that's okay with you.
Do you understand you have a right to be here at a trial since we are going to be finalizing your jury instructions and any verdict forms?
I understand that Mr. Charles explained that to me and what happens, I'm sure I'll be informed by the lawyer.
All right, so do you feel you need to talk to Mr. Charles, Mr. Erickson any more about this?
No, sir, I've been informed already.
All right, and do you, Mr. Picaro or Mr. Erickson, have any concern with him waiving his right to be here?
No, not just with the decision tomorrow.
Mr. Erickson?
No, Your Honor, and in many other cases, when it's dealing with jury instructions and things.
Well, I mean, the statute says they don't need to be here when we discuss jury instructions, but the statute says that they have a right to be here when I finalize it.
Yes.
I'm finalizing it tomorrow.
Oh, I
I want to make
understand.
sure we're clear on that.
But
I'm finalizing it.
the only one in dispute is the one you're going to decide tomorrow.
Right.
Yes.
Okay, all right. So again, Mr. Mr. Valerio, you are waiving your right to be here tomorrow when I finalize the jury instructions at around 9 o'clock.
Yes, Your Honor.
Okay, all right, you don't need to bring him over tomorrow.
Okay, okay.
All right, we'll see everybody. What do you?
Your Honor, I'm just going to hand you, and I've already given Mr. Pesci a copy of this, proposed language relative to jury instruction 18 on the depravity of mind. It
Oh,
is-
okay.
But hopefully.
No, go ahead and give it to him. And then, Mr. Pesci,
Yes, sir.
you know, you understand what I'm trying to figure out here is, does Smith say, in the future, if you're gonna do depravity of mind, it's gotta be torture or mutilation beyond the act of killing itself? And that's what I'm, you know, as I'm sitting here, and we're all sitting here quickly looking at Browning and Juror and everything like that, and I see the courts in those cases that are saying, well, you know, is this old definition sufficient? And the question I have is the Supreme Court in Smith saying, you know, from now on, if you're going to do depravity of mind, it's got to either be torture or mutilation.
This may be the last one anyone ever sees.
It may be.
Thank you, Mark.
Thank you.